Εντάξει, πήγα παιδιά. Να αρχίσουμε. Καλημέρα σε όλους.
Good day to all, Minister, Dean, Professor, dear representatives of employers and employees associations, dear friends from abroad, dear students, I welcome you all with pleasure at this moment on behalf of the Organization for Mediation and Arbitration. We're very happy to welcome you to this event. Our organization has the statutory duty to mediate between workers and employers to settle important labor disputes. We need to stress that it is one of the few bodies in Greece that is not a public law body in the classical sense of the term, but it is run by the stakeholders, the representatives of the workers, employees and employers. A lot can be said, and there are some weaknesses to be pointed out. However, we cannot deny one thing, that this organization has determined labor relationships in our country to a great extent, and I believe that this will be true in the future. This one-day event is very useful because it brings together all European bodies with similar competencies. I took this initiative because we believe that we have common experiences that we need to share, and because in our view, it is very useful to organize such common events. Hopefully, this meeting will be the starting point for a more permanent arrangement, i.e., an apparatus of cooperation, exchange of experience, and organization of common activities. Let me thank, on my part, all the people who contributed to this event, especially the staff of the organization. Special thanks go to the President of the Hellenic Republic for their response to our invitation to place this event under its auspices, and to the Law School of the University of Athens. Thanks are due to the speakers who traveled from their countries and who gave us their precious time to come here and prepare their presentations. Also the the moderators of the sessions, we thank them. I would like also to thank all of you for attending and for helping us to bring this event to a fruitful end. Finally, thanks are due to the representatives of the ILO, Valerie and Christina, for their assistance and support. I wish you every success in today's discussions. Thank you. I would like to thank the President of the OMED, Mr. Papadimitriou, for his address and congratulate him for organizing this conference. I have to admit that this is one of the most important conferences on this topic. In terms of social justice, it is through the OMED that a balance can be stricken between labor and capital. Now, on behalf of the government, the Minister for Employment, Mr. Spanakis Vasilis, has the floor. We look forward to what he has to say.
Κυρίες και κύριοι, καλημέρα σας.
Ladies and gentlemen, good morning. To those who have traveled from abroad, welcome to Athens, to Greece, that is filled with sunshine. I would like to congratulate all those who took the initiative to organize this international conference on the topic resolution of labor disputes in Europe. And I would like to thank you for the invitation, thanks to which I'm here today in order to represent the Ministry of Labour and Social Security, and for giving me the opportunity to meet distinguished representatives of the labour sector, both from Greece and from abroad. The labour sector constitutes one of the most important pillars of the economic growth, both at local and international level. It is not accidental that the unemployment rates and the employment indicators in a country reflect the growth of a country. However, the regulation of labor relations constitute a main priority of states aiming at the effective organization of production and the guarantee of an upgraded labor life, both in terms of quality and of quantity. The existence of disputes constitutes a characteristic of all interpersonal relations. And this actually allows us to understand that it can also relate to labor relations. The Greek legislation provides for the settlement of disputes, including the labor disputes, by taking the cases to courts, something that, of course, costs both in time and also in money for the employee and for the employer at the same time. So given that labor disputes will always exist, we need to highlight how important it is to settle them quickly at the lowest possible cost for both parties. The out-of-court settlement of labor disputes is the responsibility of the Labor Inspectorate for cases that pertain to violation of labor law, and the Organization for Mediation and Arbitration, that is OMED, that constitutes a unique model of social dialogue, also is responsible to contribute to the settlement. The many years of operation of this organization as an independent organization and the latest expansion of its competences following the passing of Law 4808 of 2021, and more specifically Article 28, that provides for the provision of services for conciliation, prove the importance of the services that this organization offers to the country. Allow me to say that addressing to OMED in order to settle disputes out of court is something optional and not compulsory. And this has been the result of the failure of the free negotiations of parties, and this is also a proof of its importance. It is very important that the parties trust the organization and agree to address to that organization in order to settle their labor dispute. This leads to a first agreement between them with regard to the way that they're going to settle the dispute. Moreover, the person that undertakes the mediation or the conciliation is accepted by both parties, and if that is not possible, that person is selected following a draw of a list that has been drafted and kept in the organization. In addition to that, via the organization, the parties are given the opportunity to actively take part in the settlement of their dispute, and they have the possibility to reach a win-win result, which then allows the continuation and even development of the relation between the two. On the contrary, in a court dispute, the parties cannot actively contribute to the shaping of the ruling. And it is very possible, and this has been proven by practice, that after the end of a trial, the relation between the two parties has suffered enormously. It is also a fact that we're talking about processes that lead to a saving of time and money that would be spent indiscriminately for the settlement of the dispute. What we ought to do is to strengthen the culture of the out-of-court settlement of disputes, especially in the labor sector, something that will be to the benefit not only of the interested parties, but also of entrepreneurship, of the economy, since the disputes will be settled faster, more economically, and since labor relations will continue to thrive. In our country, in Greece, we have seen an increase of posts that exceed 750,000 jobs from 2015 to today. And this actually proves that the role of AMED is of utmost importance. So I encourage you to continue in your path so that the out-of-court settlement can become part of our mentality, of our culture, and so that we can reach the best possible results for all of us. And with these few words, I would like to wish all the best to the works of the conference, and I would like to be given the conclusions. Thank you very much.
Ευχαριστώ πολύ τον Υφυπουργό κ. Φανάκη. Νομίζω η παρέμβαση...
The intervention of the minister was illuminating. But let me keep a couple of points that matter to the conference. The organization was founded in 1990, the Organization for Arbitration and Mediation, and it is among the few organizations that has been widely acknowledged and respected. In a country like Greece, where everybody doubts everybody else, it is very significant that the ministry knows that. The second point made by the minister, which matters, is that since the 80s, when we tried to develop a social dialogue, this organization has been the basic tool, instrument to promote dialogue between employment and capital. Because, in fact, it intervenes at the critical stage of disputes. Mediations and arbitration awards have improved greatly to social peace and to reducing the number of strikes. Let me also add that the latest achievement of the organization, with the assistance of government, is that it introduced conciliation as a third modality. Conciliation was nothing in Greece until now, but now it will gain some purchase, it will help settle disputes without acrimony and without bad feelings. Thank you very much. And now we'll give the floor to the Dean of the Law School.
Κύριε Υπουργέ, κύριε Πρόεδρε, κύριε Καθηγητά.
Mr. Iliadis, Professor, President, thank you very much for the invitation. I'm very happy to salute the proceedings of this conference co-organized by the Law School of Athens. The Law School and the OMED have been working closely together for many years. Mr. Papadimitriou is running the organization. He used to be an arbitrator. He had been a member of the board. And Mr. Levendis, also a law professor, had been a part of the board. Also Mr. Janetakos, also Mr. Gravidaris, since 2022. I would like on my turn to pay tribute to the role of the organization in developing social dialogue and in preserving labor relationships by signing collective agreements or by issuing administrative rulings. Since its foundation, OMED became part of a new system of free collective bargaining, and for 30 years it has been trying to contribute to social dialogue and collective bargaining, and through those labor peace and social development. OMED is the only statutory body authorized to provide mediation arbitration services to labor and employers organizations and to isolated employers to support free collective bargaining and settle collective labor disputes. OMED provides many safeguards for proper operation. The special bodies of mediators and arbitrators are governed by the principles of independence vis-à-vis government and other third parties, impartiality and neutrality vis-à-vis the parties, transparency in the way that cases are dealt with, and objectivity in the overall management of cases, in the proposals of the mediators, in the awards of arbitrators. The same principles apply to all people and operations within the organization in terms of collective bargaining and the other activities of the organization, the other services offered to society, in addition to the main activities, the main mission. And I would like to talk about them. It is training and education in collective bargaining, codification of important contracts and agreements, and their notification to the public, regardless of whether the organization had been a party to the negotiations. Also, the running of a legal library which lends books, which brings together all relevant publications, which are accessible on the organization's website. The OMED, as the minister said, recently took up conciliation, and Mr. Koukiadis stressed the importance of this subject matter, in addition to mediation and arbitration, where the accumulated experience on collective bargaining, contracts, regulations, minimum service, public dialogue, has been substantial because of the 30 years of operation and social contribution. This event offers a comparative review of labor dispute settlement in 11 European countries: Greece, Belgium, Bulgaria, Ireland, North Macedonia, Portugal, Serbia, Spain, Sweden, Ukraine, and the UK. It is a very interesting choice. We have representation of Northern Europe, South Europe, Central Europe, Eastern Europe, Western Europe. Hopefully, all this will lead to collecting primary material from all these countries, and I look forward to the rich tome that will follow with information from all over Europe. Thank you very much.
I
would like to thank the Dean of the Law School. Based on what he said and since I'm a former president, I would like to keep the faithful description of the role of the organization. And what I would like to add, especially for our foreign guests and friends, is that OMED was supported and was based on the common view of employers and employees. In other words, its main foundation, its main base was the common intention of capital and employees to work together. The Dean talked about independence. And yes, independence is a basic characteristic. The point is, how do we put independence into practice? The organization is one of the few organizations that achieved independence. And I believe that this cannot be questioned neither by the employers nor the employees. And this is a major success. And I'm saying this to the foreign guests because it proves the valuable contribution of the organization to the social peace. And now the floor.
Νομίζω πως μου δώσατε είναι
To the General Confederate of Greek Workers, Mr. Varyanis Dimitrios, General Secretary of the General Confederate of Greek Workers.
Καλημέρα σας. Κύριε
Good morning, Minister, President of OMED, professors, ladies and gentlemen, participants, ladies and gentlemen, representatives of the social partners and of the employers' organizations. Ladies and gentlemen, first of all, on behalf of YESE, I would like to thank you for the invitation to take part in today's international conference that touches upon an issue which, for us at least, the social partners, is of utmost importance. For the small and very small employers, the relation with the employees is one of the basic parameters that define the success and the development of a business. The relation and the cooperation which on a daily basis are constructed and developed, the solidarity in critical moments constitute one of the characteristics of the labor relations that we see in a small and very small business. In other words, the success of a business, of an enterprise, depends to a great extent on the quality of the labor relations that are shaped between the employees and the employer. Still, it is not always feasible to prevent disagreements and conflicts. And this is exactly where mediation becomes a tool for the settlement of disputes, so that any disputes, any conflicts that emerge will not irrevocably break the labor relation. So it is critical to promote mediation. And it is also very important that mediation looks for the fair solution. Something which, in our view, should pertain both to individual and collective disputes. And I'm referring, obviously, to the collective disputes, because in Greece, as you probably know, all of you, we have gone through a long period of 15 years of consecutive and parallel crises. There is no other European country that has encountered what we encountered here in Greece. Especially during the first fiscal crisis, what happened was an unprecedented disaster and in circumstances of peace. And the data speak for themselves. In the deepest recession of the era of memoranda, 2013-2014, 200,000 businesses, to the greatest majority small and very small ones, disappeared from the business map, something that led to the loss of approximately 1 million jobs, or to the skyrocketing of unemployment to 27%. At the same time, the GDP of the country dropped by 25%, whereas the available income of households was reduced by 33%, and the signs of the private debt were also very worrying. One of the main victims of this period was social dialogue and the free collective bargaining. which led to the social partners defining the minimum wage on the basis of the national collective labor agreement. And this actually did not provide the necessary circumstances so that during the relevant negotiations between employees and employers for an agreement to be reached. The majority of the contracts ended up in mediation, and the parties, in most of the cases, would remain steadfast, and the settlement of this actually was depending on the arbitration. So many sectorial contracts were the result of decisions, most of which did not maintain a balance between the capacities of the businesses and the needs of the employees, and on top of that, taking into account the general economic circumstances, this was aggravated even further. Generally speaking, we can say that this very difficult time now belongs to the past. The economy is in a far better state. The unemployment has dropped significantly. Today, it is close to 10%. The sectorial collective contracts that end in an agreement between the parties have increased. Generally speaking, we have returned to normality, even though the wounds from the multiple crises have not been healed totally. We believe that the return to economic and social normality will have to be accompanied by a return to institutional normality. This means full protection of the free labor relations, strengthening of the social dialogue, possibility of defining the minimum wage by the social partners through the national collective labor agreement. These are the main priorities for the General Confederate for Greek Workers, and in that context, and always in relation to the mediation and conciliation, we can say that we now need to place emphasis on strengthening the institution of mediation and not arbitration, and to strengthen OMED, which we believe is one of the most important organizations, and therefore we support. That is why we are going to follow the discussions of this conference, and we are going to learn about other European examples. And I'm sure that what we will hear will be highly beneficial to all, and a source from which we can draw ideas for the further improvement of the settlement of a dispute system. Thank you very much for your attention, and I would like to congratulate you on this excellent initiative.
I
would like to thank the General Secretary of the YESEVE, and I would like to keep 2 points that I find interesting. YESEVE represents the small medium enterprise, which are majority in Greece, and along with the SEV, which is the Organization for Employers. The second thing he said, and it's very important, is that OMED promoted the collective bargaining, and out of the disputes that ended up in OMED, 60% ended up in mediation. And this is very important because it did not exist in the past. This is an achievement on OMED. The rest was going to the arbitration. And this is another very interesting point. And that is that in Greece we have established the compulsory arbitration. In the beginning, YESE was against the arbitration. Then the employers and the employees accepted it as a means to reduce the state intervention. Instead of having the ministers intervening, it's better to have an independent organization. Then part of the employers questioned it. It was questioned at courts. It was abolished, and then it came back following a decision of the Council of the State, and it became a constitutional institution. Maybe this is not that interesting to our foreign guests, but what is interesting is that compulsory arbitration in Greece, which the YESEV did not recognize was the critical element that guaranteed the minimum wage for the employees in small medium enterprises who could not negotiate nor strike. The cleaning ladies, how would they get their wage? The guards, they didn't have trade unions to speak for them. So this actually guaranteed a social justice. So in that sense, the arbitration in Greece was, I would say, highly beneficial and led to balancing out of the situation. Now, following the different reforms, its role has slightly diminished. But this has happened because the government has promoted conciliation. And I would like to say, General Secretary, that it's not just mediation, but it is also conciliation that plays an important role nowadays. Why? Because conciliation gives the employers and the employees the possibility to take a case before the court without being afraid that this case would end up in arbitration. Whereas in the case of mediation, they knew that arbitration would follow. So, with the help of the General Confederate for Greek Workers, we have seen this promotion of the role of conciliation, and we should strengthen it even further. Thank you very much. Now, let's move to the representative of SEV, the Greek Organization of Businesses.
Καλημέρα και από μένα.
Good morning on my part. On behalf of SEV, the Hellenic Federation of Enterprises, thank you for the invitation to participate in this very important international conference organized by the OMED, a topic very important for social partners and SEV in particular. I heard the professor. He gave me a sig into what I wanted to say. We believe in a settlement system of labor disputes based on free collective bargaining, which is a very important instrument to promote social peace, progress, development, and the economy as a whole. It is a means by which the trade unions determine conditions of pay and working conditions for the various working people. A very important step was made by creating the OMED on the initiative of all social partners, but mandatory arbitration, as the professor said, even after this initiative, is an obstacle to collective bargaining. It doesn't allow the parties to define themselves the terms that should apply to their relationships. The International Convention of the ILO, ratified by our country, and the European Charter acknowledge the importance of collective bargaining. Act 2019 limited mediation to very specific cases and only as the last resort in labor disputes. However, in practice, this act is not implemented, and as a result, mandatory mediation is used in cases where free bargaining should have been chosen, with respect to the parties and with a view to the economy. We believe that it is only to the benefit of collective bargaining and the social partners, and the very efficiency of the operation of OMED can help the following: changing the institutional framework of collective bargaining in accordance with the international conventions of the ILO and the European Charter, the evaluation and reshuffling of the OMED statutes with emphasis on conciliation and mediation, as is the case in most European countries, and we look forward to listening to examples from other European countries today. Also, the registry of trade unions and other organizations in order to ensure transparency and representativeness. With all these steps, the autonomy of the partners is reinforced, and this has benefits for the economy as a whole. Thank you very much. We look forward to listening to the conclusions of this event.
Σας ευχαριστώ, κύριε Δασκαλάκη.
Thank you very much, Ms. Daskalaki, for everything you said on behalf of SEV, the Hellenic Federation of Enterprises. What I would like to add is related to what you said. When we had the negotiations for the law, I was responsible for these negotiations, for this bargaining, and SEV was against these. And I tell them, you don't want arbitration? I'm asking. All these small, medium enterprises that will not be able to proceed to collective agreements, how will they ensure a minimum wage, a minimum increase in wage? Then it was that they terrified and they said, yes, we don't want state intervention. So OMED, the organization, was, if you like, something that stopped the state intervention, and it did a great job. Then, when did things go south? Especially when the crisis broke out. Instead of having small, medium enterprises taking cases before the court, we had also big ones doing the same. And this is where the recipe actually turned bad. And that is why, after the law, we have reduced the possibilities of taking cases before the court. We have reduced the role of compulsory arbitration, and that is why we are very close to the position of the General Confederate for Greek Workers that is in favor of mediation. And now the floor to Mr. Georgakopoulos, who is Secretary for Economy. Yes.
Και τη θέση της ΓΕΣΕ.
Καλημέρα σε όλους.
Good day to all. Let me thank the President and the Board for the invitation. I believe that this initiative on organizing this event is very important for us at a time when the topic of collective agreements and mediation and arbitration are to the forefront very much, and it is among the proposals of the General Secretariat of Workers. This is an ancillary mechanism sustaining collective bargaining, and for sure it should lead to signing collective agreements or even arbitration awards. For us, it is positive that this organization is run exclusively by the social partners, and the president is elected by unanimous decision of the members of the board. OMED and its activities and operations were fought by governments during the crisis and during the laws of the last 15 years. These measures led, in our view, to the following results. They reduced wages. The terms between pay and work passed from a collective agreement to the individual agreement with the employer for the vast majority of workers and employees. And a working party without their collective bargaining is a weak party. There is a low coverage of workers and employees, and this despite the obligation of our country to incorporate the directive of the Council of October 2022, which imposes the reinforcement of collective bargaining in determining pay, which obliges member states where there is a coverage rate less than 80%. In Greece, it is 24% according to the latest information, to lay down an action plan to increase the coverage ratio by collective agreements. The legislative framework is asphyxiating and does not help collective arrangements. In 2014, the plenary session of the Supreme Administrative Court issued a ruling upholding a claim by YESE against the second memorandum as to the unilateral ability to seek mediation and arbitration on all the conditions of pay and work. Unfortunately, despite this decision of the plenary chamber of the Supreme Administrative Court, the government did not comply with its subsequent laws. It keeps adopting obstacles to the operation of OMED. The unilateral right of appeal was shrunk. And very few cases, only in utilities, when there is a general interest associated with the operation of the national economy. This led to the result that a huge number of collective disputes, especially from the private sector, cannot be settled by the OMED, and there is no opportunity of collective arrangement, of collective organization in case negotiations fail. Ladies and gentlemen, another competence entrusted to OMED is the conciliation procedure. For the moment, we don't have any measurable, quantifiable results from this activity. What we can say is the following. If this competence is not associated with issuing binding decisions or sanctions for those who do not participate in the procedure, makes this institution less effective. So all of us have a duty, and it is also a need for the economy and society to reinforce the role of the Organization for Mediation and Arbitration. This presupposes the reform of the institutional framework through which the organization operates, and also the preparation of legislative interventions that will support the organization in its efficient operation. Thank you very much.
Λοιπόν, ευχαριστώ τον κύριο Γεωργακόπουλο.
I would like to thank Mr. Georgakopoulos. He focused on the crisis and on the results of the crisis, on the limitation of the collective bargaining agreements. So on the points that are the main concern of yes, and I hope that we will eventually restore the past balance. He talked about conciliation. I would like to repeat once again that be mindful of the conciliation, because if we strengthen conciliation so as to prevent mediation arbitration, then we will be able to ensure that the agreements will be the result of conciliation. And we need to know that mediation terrifies the employers, because they know that there is a possibility of that ending up in arbitration. If we want to prevent that, then we will need to promote conciliation. Anyway, it is a hot topic. We will see later on more speakers talking about it. So this was the first round. I would like to thank all those who took the floor. And now we can proceed to the main part of the conference.
Λοιπόν, πρώτος ομιλητής.
The first speaker is Mr. Jean-Michel Servet, an old friend, Professor Emeritus, but also General Secretary of the International Labour Organization, with long and huge experience in labor issues at the international level. That is why it is a great honor for us to have him with us here today. He will present to us a comparative approach to the issues of arbitration and mediation. So, you will allow me, since I'm the first chair of the conference, to say a few words about the main topic of the conference.
Οι διαφορές που πάνε στη μεσολάβηση της χειρητησίας, οι λεγόμενες συλλογικές.
The collective disputes or the disputes of interest constitute the big conquest of the legal world of the 20th century. Before the 20th century, these did not exist. The only thing that existed back then were the individual disputes, in other words, individuals taking cases before the court. So the collective disputes are the ones that do not pertain to the interpretation of the law, but they are the ones that create law. And this is the major difference. It is what we call de juris. In that sense, they constituted for the 20th and 21st century the basic institution for social justice. How else could we have social justice if we didn't have the possibility for the capital and the employees to come to an agreement to then lead to salary increases and so forth? So this is the basic tool, and we need to keep this in mind as the major achievement in the 20th century. And now, in our century, we need to make sure that these institutions will be further promoted, since they constitute one of the most effective tools for social justice, the institutions of mediation, conciliation, and arbitration. And now we will see, thanks to the presentation by Mr. Servet, how these institutions work in different states. We will get an experience from other countries, and then the rest of the speakers will share with us their experiences in their own countries, always with regard to the institutions that I mentioned previously. Mr. Servet, you have the floor.
Παρά η δική μου, αυτή τη στιγμή ο κ. Σεβέ είναι πρόεδρος.
Right now, Mr. Servet is the president of the International Society for Labor Law and Social Security.
Kalimera. Good morning, and many thanks to the organizers, Costa Papadimitriou, of course, another old friend like Yanis, and Spiros Vodiatis, who was the man behind and helped me a lot in my preparation of this trip, and many thanks to Ahmed. And I wish also to greet my colleagues from the ILO that I know also from years. It's a pleasure to participate in such an interesting conference with colleagues from so many countries, to collaborate with Kostas, and to be once again in the marvelous Athens. I have proposed to discuss the transnational dimension of collective labor disputes today. A number of industrial relations takes place now on a European or international level. However, there is very complex issues to be settled, and many questions are raised without any answer. In addition, major multinational firms undertake either unilaterally or through collective bargaining with trade unions to respect minimum labor standards in collective agreements or in codes of conduct. And here also, the legal answer is quite complex. Indeed, these codes of conduct, like the collective agreements, have their own supervisory mechanism, but in the case of unilateral codes of conduct, it depends basically on the independence and the competence of the social auditors which are appointed. If we go to the legal views, it becomes extremely complex, and depending on the system, you may consider that this unilateral commitment of enterprise are binding in all the civil law countries, basically. But in the common law countries like Britain, it's only an implicit clause in the individual contract, and even more in the United States, it is a kind of, it engaged the responsibility of the firm as a false public statement. All that to say that the transnational collective dispute, labor dispute, have no real procedure today to settle them adequately. So in the first section of my presentation, I will try to characterize and define what is transnational collective labor dispute. And in the second one, my argument will be, let us look at the ILO procedures, at the mediation procedure in the ILO, and see if we can have some inspiration from this. With regard to the transnational labor disputes, I would say I could mention three hypotheses. The first is like recently in France, you have a transport worker strike that affects not only people in France, but in other countries. I was interviewed by the BBC asking me, well, how could we impede the negative consequences of this transport worker strike from the transportation of goods from France to from UK? And indeed, there is no real solution. But this is a civil law liability problem from a labor law problem. It's a purely French problem. Second hypothesis, a group of the workers are foreigners. But again, this is not too complex because we could use the domestic international private law to see which law is applicable, including for collective disputes. The real problem came when the activities are international. Let us take a purely fictional example. The Volkswagen Group, the workers of the Volkswagen Group decide to go on strike. And you have strike in Spain, in Germany, and in the Czech Republic. Here we have a need of a real international, transnational solution. Well, let us see quickly what are the solutions available. We have to distinguish here between the conflicts of rights when the workers try to obtain the execution of their rights, and conflict of interest when they wish to improve their rights. It's a very classical distinction. For the first, you have at the European level some rules, but these rules indeed are not very helpful. For the individual rights, you have a specific Article 8 in what is called Rome I to settle that at the European Union level. At the collective one, you have some general rules, but let us try to apply them. What is the law suitable for a company or group-wide agreement? What is the law most connected to that? Or the habitual residence of a collective agreement signed by three national confederation of the unions with the employers. This is rather complex, not to speak about negotiation without agreement. And you have no similar rules for the conflicts of interests. indeed, you have only one article in Rome 2 saying that that the parties, in case of strike, the party which are causing damages could be liable for the damages. Well, fortunately, in a number of European countries, we can use other articles saying that when both parties have their habitual residence in a country, the law of that country could apply, and other provisions saying that the regulation should not undermine the provision of the law of the place of the jurisdiction and respect public order. So the liability could be applicable in countries like UK, but it's not necessarily the case in other countries like France. Last but not least, for the posted workers, you have very famous cases explaining how difficult it is to settle a transnational conflict. So my argument is, let us look at what could be offered, especially by the ILO. Well, the ILO is producing convention and recommendation indeed. But only that, you have all kind of guidance, recommendations, and other soft law that could be also used. Basically, I will retain two. The first is within the supervisory mechanism of the convention, the application of the convention of the ILO. We all know that the conclusions of the supervisory bodies, this committee of experts or committee of freedom association of others, are not compulsory. They are recommendations. They are not compulsory. Only a recourse to the International Court of Justice would be. So, without this basic pressure, the ILO is obliged to use other mechanisms. Which mechanism? Technical cooperation, for sure, when the country is ready, the government is ready to collaborate, and mediation. And when I was ILO official, I did a lot of this mediation within a country or between countries. And in that case, you have to, I would say, adhere to certain fundamental principles in your mediation. The right of the defendant to have the last words in the exchange of argument, for example. The fact that the consideration of each country's individual circumstances could be taken into account only for the, for the implementation of the conclusions, but not in the process of evaluating the discrepancy with the ILO. So that means that you take it, you first see the violation, and then you look how to do it, and then you take into account the circumstances. There is all kind of unofficial contacts, but beyond that, if there is also something which is not very well known, but has been used by the ILO from time to time, and it has been even formalized with a help desk used today. When some firms, multinational in general, have a problem, they can call the ILO and ask for advice. And indeed, in a certain case, I could, if we have time during the lunch or the dinner, I could give you example with IKEA, with other firm. If they ask for a solution, the ILO informally could also give a solution. If you look at the norms of the ILO, you have two recommendations. They are not extremely detailed. because basically the two parties, the workers and the employers group, wish to be free in their contacts with each other. So you have no convention because there would not be any consensus for a convention on this, but you have recommendation. And this recommendation insists on some principle that could be useful for all of you. The first is that when a procedure of mediation, conciliation, arbitration is established by collective agreement, there should be a clause saying that it should be no strike during the period of conciliation mediation. This peace obligation is either absolute, no strike at all, no action at all, or relative, that means on the points mentioned in the collective agreement. Normally also, the Committee of Freedom Association say during the duration of the collective agreement, we could accept that there will be prohibition of strike during that period. The same recommendation say no one could be excluded for the normal claiming procedure. That's clear. But there is something new in the United Nations guiding principle on the business and human rights, which could be also of use to you. I read especially paragraph 31 of this guiding principles, and they insist on some basic principles: legitimacy, accessibility, predictability, equity, transparency. It should be right compatible, of course, and a source of continuous learning and based on social dialogue. But there is another recommendation of the ILO on voluntary conciliation and arbitration. Compulsory arbitration should only be possible, according to the ILO, if the two parties agree on that. If not, it would be a prohibition of the strike. Free of charge in principle, but the Committee of Freedom Association accepts some costs if it's still reasonable. Normally, ideally, it should be joint-based bodies of arbitration or conciliation with equal representation of the two parts, and the parties should be encouraged to accept the arbitration awards, even if it's voluntary. If we look at the framework, the transnational framework agreements, most of them are just providing bilateral bodies of supervision. But in the most difficult cases, they also welcome arbitration boards. So beyond what you have at the national level, there is also indeed a future for arbitration at that level, especially, I would say, because there are no clear legal solution, including for the conflict of rights, for the conflict of interests. The national procedures are rather difficult to implement when more than one country is involved. And it's not only, and I would insist on that, a question of different law, but it's also the question of a different concept of industrial relation depending on the country. Let us take the question of the strike. In some common law country, it's still a freedom. That means that the employer has also the freedom to dismiss the striker. In France, on the contrary, it's a constitutional individual right. In Sweden, it's a collective right. That means that only trade unions may launch a legitimate strike. Let us see the collective agreements. It's the so-called gentlemen agreements, engagements on the honor in Britain to a large extent. In France, as in a number of other countries, Spain, Belgium, you have, on the contrary, it's not only compulsory for the parties and their members, there is extension procedures, like, by the way, at the European level, European Union level, extension. In other countries, you have other ways, especially in Central Europe, other ways to extend the collective agreement to all the workers in the company. Not to speak about the trade unions. The concept even of trade union is different. If you look at the trade union in the United States, it's business union. They work for their members in the company, full stop. If you go to European, Western countries, it's the defenders of the working class. So you have there also different concepts. And to put all that together is extremely difficult, legally speaking. I was part of a committee of experts at the European level saying, could we create a directive of regulation on mediation, conciliation, arbitration? I was in the minority of the group saying, you will not be able to do so. Well, I was right. So let us promote mediation, conciliation, and for that, I think the inspiration of the ILO experience could help a lot. Many thanks.
Ένα δύσκολο θέμα που...
A very difficult topic, which in our case is not very accessible, to put it this way. The international labor disputes, the disputes having a transnational character, if you like, which in today's era of globalization are a fact, need to be dealt with. He talked about the difficulties of dealing with this issue. There are no magical solutions for the time being. However, the ILO, through their recommendations, with the experience of soft law, plays an active role. And that is why we can say that it's not always necessary to establish regulatory rules, because only with recommendations we can get some very good results. And as Mr. Servet said, it was the recommendations that were made in the cases of multinational companies disputes that conciliation and dialogue was promoted. There is this soft law that can be highly helpful in many cases. I would like to say to Mr. Servet that in Europe there is also the problem of the conflict with the European law and the recourse to the international court. There were some international disputes that had to do with trade unions from the Baltic countries, and the court ruling actually provided the solution. And correct me if I'm wrong, in Europe we have a particularity when we talk about this issue. And would you like to say something about that? About the international labor disputes at the European level?
Basically, I could be very technical, but I think it's not the place here. My argument is that if you have at the European level a collective dispute, a real collective dispute, that means that activities in several countries, you have a strike, you have really no regulation which is applicable. And there is a need for that. That's why we had this group of experts proposing a directive. But it was not successful, basically, I think, because the government preferred to keep that under control, and the two social partners prefer to organize them themselves and not to have other regulation for that. So my argument is that we should try to establish at the European level, like at transnational level, teams of mediators to be able to settle the question. You have a very first step at the European level with this labor administration, I don't remember exactly the name, labor administration, labor authorities, where the labor inspector, basically, of the different countries could, you wish to give the name? No? May try to conciliate between them when there is a problem. This is a very first step. And I think for a major conflict, there is no rule. So, and I would consider that there should be something more clearer. At the transnational level, I would say that there is something that the ILO could do, is to have a new convention indicating the law applicable, the competent jurisdiction, and the procedure to execute foreign decision at when a conflict have imply more than one country. So that's it.
Ευχαριστώ για τις συμπληρωματικές.
Thank you for this additional information. We will give the floor to the second speaker, the president of the OMED, the Emeritus Professor Papadimitriou.
So, once for me, the Greek is now the settlement of labor disputes. The establishment of collective labor dispute settlement procedures has for decades been an important component of Greek industrial relations. The settlement of collective labor disputes in Greece remains an issue that generates doctrinal debate, jurisdictional disputes, and social tension. There are three procedures provided by the law: conciliation, mediation, and arbitration, and each one of them has a different function, even if the task performed by the third person who intervenes to settle the disputes can be overlapping. Let's see first about the Greek organization, OMED. The Greek legislature established in 1990 a private entity, OMED, whose task was the establishment of the mechanism of settlement of collective labor disputes. OMED does not have the nature of an administrative function, not even an autonomous administrative body, but rather it acquired the legal form of a private entity regulated by private law. The purpose of the legislator was obviously at this point to exempt the mechanism for settlement disputes from the state interference. It is managed jointly, as it was said, by employers and employees, provided the three procedures. Yes. What are the main characteristics of AMED? Two elements relating to AMED must therefore be emphasized as strengthening its effectiveness in particular. First, its board of directors has no connection with the state apparatus. On the contrary, employers and workers' organizations equally participating have the primary responsibility for the functioning of AMED. Secondly, the choice of mediators arbitrators is done in a way that ensures their objectivity and their ability to perform their highly sensitive work. The president is appointed by unanimous decisions of the social partners. There is no state funding. AMED was formally financed by employers and employees' contributions and actually is financed from employees' contributions. No fees are paid by the social partners asking the services of AMED. And finally, there are two premises, two offices, one in Athens and one in Thessaloniki. Let's pass to the conciliation. Conciliation is the first stage of the collective labor dispute settlement procedure. It's the method by which a third party, conciliator, tries to facilitate the contact between the parties with a view to reaching an agreement. Conciliation may concern all types of collective labor disputes arising between employers and employees. It may also concern individual disputes presenting, however, a collective interest. Purely individual disputes are not a question of AMED, it's a question of the inspectorate perhaps, but not of individual presenting a collective interest, yes. After a recent change of the legislation, the conciliator is actually entrusted to AMED. The request for the conciliator's intervention might come either by the competent trade unions, on the one hand, or from the employers' organizations, on the other hand. The conciliator is chosen by a special list of mediators, which form a particular body with the framework of the AMED. If the parties don't agree on the appointment of a mediator, conciliator, the same here, he is chosen by lot among the mediators of AMED. Finally, there is no recommendation after the end of the conciliation, only a contact, but no, this is the difference perhaps with the mediation. Here, there's no final recommendation. Perhaps there are informal recommendations during the procedure, but not at the end something official. This new competence seems actually, as it was mentioned by Professor Koukiadis, to be one of the organization's main responsibility, taking into account that the number of the mediation request has decreased. So we wait more conciliations and less mediators or arbitrations. And let's pass to the second, the mediation. If the parties cannot reach an agreement during negotiations or during conciliation, mediation is possible. It's available only for disputes arising between the parties to a collective agreement. That means only collective agreements disputes as concern the mediation. The mediation is chosen by the specialist of mediators in the same way. If there is not an agreement between the parties, there is appointed by lot. If the parties cannot reach an agreement within 20 days during the mediation, the mediator must present a recommendation. This is the difference. Here we have recommendation. The law obliges expressis verbis the mediator to justify his recommendation which must be notified after to both parties to the dispute. The parties to the dispute are free to accept or to reject the mediator's recommendation, since it does not create any rights or obligations for the parties. And now the last step, the arbitration. The system of collective labor dispute settlement, and more particular arbitration, has marked the Greek collective industrial relations system for a long period. The process of settling collective labor disputes following an unilateral recourse to arbitration that had characterized Greek collective relations over the last 20 years, often providing a solution to several serious labor disputes, but this system has been abandoned in 2012. It was the time of crisis. Subsequently, it was the Greek Council of State that ruled in 2014 that unilateral recourse arbitration was in compliance with the principle of collective autonomy and the freedom of bargaining, and also, quite paradoxically, that the Greek constitution requires the legislator to establish an arbitration system providing for the unilateral recourse. Finally, the legislator, complying with this decision, has reintroduced such an arbitration system. However, this system also attempted to limit the power of arbitration in multiple ways. First, by providing arbitration committees instead of single arbitrators. Secondly, by providing a second level of arbitration where arbitration committees are composed mainly of judges, and thirdly, by providing for extensive judicial review of the reasoning of arbitration rewards. Finally, in 2019, the unilateral recourse to arbitration was further limited. Recourse to arbitration can take place, firstly, surely, by common agreement between the parties. But the law also provides two cases for unilateral recourse arbitration. First, in the context of essential services, and second, in the context of disputes concerning the general interest of the Greek economy. Therefore, unilateral recourse arbitration is considered an exceptional step either in the case of refusal by the one of the parties to participate in dialogue and bargaining, or in the other case of rejection of the mediator proposal. The choice of arbitration is the same way, either by common agreement or by lot. And the arbitration award has the force of a collective agreement. Consequently, all provisions relating to collective agreements apply by analogy to arbitration awards. This system functions until today, but in a less decisive way than in the past. Less arbitration awards are currently being issued. Only 5 awards were issued in 2021, 5 in 2020, 1 in 2021, 4 in 2022, and 5 in 2023. That means not an important number. And now let's pass with the status of mediators and arbitrators. With the framework of the OMED, there are two independent bodies, one of mediators and one of arbitrators. Although the members of these bodies are public officials according to the law, they don't have the status of civil servants. In terms of qualifications, they must have a university degree of law or economics and have relevant experience in the field of industrial relations. They must also perform their duties objectively, and they have to observe the code of conduct of the body. The mediators and arbitrators are linked to OMED by virtue of contracts for the provision of services, not civil servants, provision of services. The legislator, in order to facilitate negotiations between the parties, formulated this permanent body of experienced and trained experts who can execute their duties independently from external interventions. The credibility of the mediators' arbitrations is not based on the position of high hierarchical ranks or some other qualities, but such credibility is safeguarded through their participation in a specialized and independent body. The selection of mediators and arbitrations is made by the Board of Directors of OMED following a public notice. The choice of mediators arbitrator is done in a way that ensures their objectivity and their ability to perform their work. Indeed, in order to ensure the selection of persons of general acceptance, it is stipulated that, in particular for the recruitment or renewal of the term of office of mediators or arbitrators, a unanimous decision of all members of the board of the directors is required. That means both employers and employees has to agree. Additionally, as stated in the law, mediators and arbitration enjoy fully independence in the performance of their duties. OMED is not, however, staffed by full-time mediators and arbitrators. Since the legislation provides that the legislation does not exclude the possibility of parallel occupation of members of these bodies in other professions. Most of them are lawyers also. This freedom could be considered an element further promoting their independence. Furthermore, the terms of office of the members of arbitrators and mediators is 3 years and may be renewed. It is evident that the 3-year term of office of mediators arbitrators aim to periodically evaluate the satisfactory manner of carrying out their missions, as well as the spirit of independence towards employers, employees, and the government policy. The explicit reference made by the legislator to this independence is directed at both the directors of the organization and the public authorities, so that the mediators act only on the basis of their conscience and not on the basis of the governmental policy. The members of the bodies are trained regularly. Sections of exchange of experience are regularly organized. Indicatively, a training of the new and all members of the bodies was organized in 2022 with the collaboration of ILO in Athens and in Turin. Valerie knows well. And let's finish with the extra version of OMED. OMED organizes seminars in different Greek cities in order to contact employers and employees and to communicate its activities to them. It organizes from time to time national and international seminars. It publishes reports and prepares studies on collective bargaining issues. There are some contacts also with similar organizations in other countries. And finally, there's a frequent contact with the international labor organizations. Thank you very much for your attention.
Ευχαριστώ τον Πρόεδρο.
I thank the President and Professor, Mr. Papadimitriou, who, in the short time allotted to him, made a full and accurate description of the OMED's role. I think he gave the full picture of what it is, what it does, and what are the outcomes in practice. Now, our third speaker.
Από το Βέλγιο.
From Belgium, Mr. Guy van Hees, General Direction of Collective Labor Relations.
I hope that this conference is the beginning or the start for more extending and deepening the networking, I think, between our different organizations. Okay, I will talk about the Belgian case, and you can summarize with one word. It's only about conciliation. So I can finish my presentation. No. So you asked me some things more. I think two basic elements. On the one hand, who we are, and secondly, what we do. Who we are. I'm the Director General of a service. It's called DG Collective Labor Relations. So it's not only me. It are 90 other people. And maybe it's important because we are from the Federal Ministry of Work in Belgium. But this ministry has in its title social dialogue. And I think not many in Europe ministries of work have already in their title social dialogue. So we have a separate department, and that's my department, to prepare, promote, implement policy on collective labor relations, support social dialogue, prevent and resolve industrial disputes. And there, of course, I have a department of 18 social conciliators that are involved in conciliation and mediation. What is the job of a social conciliator in Belgium? It's a very specific and unique role. Like I said, it are public servants assigned to the post by the king, royal decree. We have still a king in Belgium. The requirements are fixed by a royal decree, so they need, in general, a university degree. And also, and that's, I think, very important in Belgium, ample experience in social dialogue. On average, 6 to 8 to 10 years that have been involved in collective bargaining, in social dialogue in Belgium. Also, they are introduced on a very high grade in the public service. Normally, it's not possible to get recruited on that level, but they are recruited on this A3 level. Of course, they have to be neutral, autonomous, and they are, to a certain extent, under the authority of the minister. But of course, I am the direct chef of them. And that way, I will come back to several times. They have a double role. On the one hand, they are presence of the joint sectoral industrial committees in Belgium. And on the other hand, they are conciliator and mediator. And that's, I think, very important to grasp the Belgian system. There's a link with something others, namely these official sectoral joint committees. Since 2013, they also have a role in the public sector, because in the public sector we don't have collective agreements, because it's only statutory employment. But I will focus on the issue of private sector. Like I said, what they do, they maintain contact with the social partners, they analyze and assess interpersonal situations between the social partners, they help to stimulate dialogue between parties in conflict, often within very tight deadlines, and help develop and promote alternative solutions. They are a facilitator. They chair the meetings of the joint committees, provide legal, technical, administrative, and other support to the social partners. They report on social negotiations to the minister or on other issues, for example, to the National Labour Council. They deposit the collective agreements agreed in the joint committees, and supervise the work of the secretaries to help make the minutes of the joint committees. You can here read the kind of competences you need. I will not go into details, but maybe the last one is getting more and more important. Mastery of emotional elements, also verbal aggression. To cope with verbal aggression, have a sense of communication, intuition. It's very important. You can't be an introvert person if you are a social conciliator. You have to be an extrovert. I think that's something that you have to have. That you, when you come in a room, that you don't sit in the corner, but you just say, "I'm here. I'm the president of the joint committee. I'm the conciliator that hopes to help you get an agreement." Like I said, very important, the link with these joint committees. These joint committees are set up officially by a royal decree, and the competence, which field or which part of the economy they cover, is set in a legal act, in a royal decree. They are involved in a lot of things in Belgium. For example, they make collective agreements. They have to make collective agreements on the individual training right that is now introduced in Belgium. So they have a long list of things to do. But of course, the core issue is making collective agreements, but also play a role in, I will explain later, in conciliation. And these conciliators are at the same time the president of these joint committees. So they are already in the network. Some figures of these joint committees: we have 100 sectoral conjoint committees, 65 subcommittees. It's about 5,000 more mandates that we are arranging. It's about 3,000 people. Approximately there are 1,500 meetings of these joint committees every year at our premises in our ministry. Normally, or sometimes externally. And they sign, but that's in a 2-year period, about 2,500 sectoral collective agreements on all kinds of teams. On the right hand, you find some examples. For instance, healthcare, the biggest ones. They also have all a number. So in Belgium, you talk about the number. You say the healthcare, the joint committee, 330. Construction is 124. Metal is 111 and 209. Hotels and restaurants, 302. You see there how many employers and workers. And the biggest one, that's a particular one, it's called Auxiliary Joint Committee. Why we have this? Because every worker, every employer in Belgium knows the moment that an employer for the first time declares employment to the Social Security agency. He has to say, this is my joint committee. My activity, I think that belongs to this joint committee. There can be disputes about it, etc., but he has to choose one. So in Belgium, everybody knows I belong to this. When there's a collective agreement, 330, yes, I'm a nurse, I know it's 330. I can find my sectoral labor conditions in this joint committee. For example, another one, maybe more complex one, working in a perfumery, perfumes, that sells perfumes, is the chemical sector. It's not retail. It's the definition is it belongs to the chemical sector. So he or she has to look to. For retail, we have all different companies. When it's a garage, cars, it's 112. But when you have a small shop selling, clothing, it's 311. It's the retail, non-food retail, etc., etc. To summarize, so we are public services. We only are involved in collective disputes. Of course, it's the social partners, the involved actors that can ask us to conciliate and mediate. But also the minister can appoint a conciliator. But of course, in practice, always the parties have to agree. What is more important? Of course, the social partners are, like almost in everything in Belgium, I think, involved. So we have not a board or something, but of course we have the National Labour Council that supervises and can give always an opinion about it. But of course, it are civil servants. So they are managed by the statute of the civil service. I'm a director general. Mine is a mandate that every 6 years is decided. Yes, that may be the most important things. Like I said, the job is also conciliated. So the most important, it's interwoven with the role of president of sector joint committees. So you can define it as a central outsider, but experienced inside the network. That's a bit the role. They are not the network of social partners. It's a very important policy network in Belgium. They do a lot. And he is a kind of an outsider, but he is inside the network. That's the global idea. The rest, yeah. We have certainly an issue of trading because it's a very particular type of activity. And what's the particular type? Because it's, of course, when you talk about mediation, certainly in the case of justice, justice department, it's very often done by lawyers. It's an issue of lawyers. We think it's not our ideas. Conciliation is something you do without lawyers. But lawyers complicate the things. You always have these legal things. And that we don't like. We do it in the Belgian way. We try to conciliate. So it's more a kind of, the function is more a kind of diplomacy. It's more a kind to compare with a diplomat. That's maybe more the definition of it. You have to be a diplomat. That's maybe the key issue. And it's also to do with it's never, of course, we know, certainly in the literature, mediation is also individual cases. For example, about divorce. But here, of course, it's always the group dynamics. You all the time have to do with group dynamics. Even when you're president of a joint committee and they think it will be a technical meeting. After half an hour, it will be done. It will be closed the meeting. And then the meeting prolongs to 6-7 hours. Because even on the technical issues they can have, because it's always political. When social partners meet, it's political. They join each other to have a nice talk. It's not like here. It's always political. And so it means that every meeting that they have, even when it's very technical, can be already political. And that's, of course, what this person has to take all the time into account that he has to have. It's a political issue. Okay, procedures. Maybe I have to look at the time, how much time I have still left. Okay, that I will skip. That's something you know. Like I said, we only have conciliation and mediation, no arbitration. It's voluntary process. It's outside the court. That's the big issue. And of course, confidentiality is the main principle. Everything that's said around the table in conciliation is not put into the social media. And that's, of course, sometimes more and more difficult. But that's the general idea. So the legal framework is, of course, linked with the regular system of social dialogue. And, of course, normally we think the social partners have to solve their conflicts by themselves. That's the first principle, the autonomy of social partners. And, of course, the trade union delegation, the shop stewards, you could say, play a major role in that. They, of course, have to also try to help to solve conflicts at company level. It's part of their job, also, and certainly for the trade union officers. But then we have two other types. That's on the one hand, and that will I explain very extensively, but I think it's very particular for the Belgian system. It's conciliation board, where the national social partners play a role in the conciliation. They are the conciliators. The national ones have to conciliate and help to solve local conflicts. Again, the autonomy, responsibility, social partners. That's the first one to have to do it. Yeah. Conciliation Bureau. So that I will explain a bit more in extensive. Again, it's about preventing in all collective conflicts. Participation is voluntary, so some of the actors have to ask it. Like I said, it's not arbitration. Of course, there's a procedure that allows for flexibility, creativity, and confidentiality is important. So here you can find how the conflict can escalate. And at a certain point, you have this. The problem is on my slide is so small I can't see it. Intervention of so somebody can ask that to the president of the joint committee, I want on my local conflict, for instance, the trade union representative or the employer, I want to have that the bureau will be assembled, the board will be assembled, and that we can explain, discuss our problem, and we want a recommendation, a conciliation from your side. Of course, in some sectors that is all very strictly arranged by a collective agreement. For example, you can't go on strike if you don't also do an appeal to the Conciliation Bureau, but it depends on the sector. Of course, then this Conciliation Bureau, the president, my social conciliator, assembles as quickly as possible. You do already some bilateral talks, see what is the issue, etc. He informs himself. And it can be on all types of things: economic conflicts, strikes, stoppages, also requisitions for minimal services. Also, very in general, the respect for the social dialogue at company level, corporate restructurings, interpretation of a collective agreement. So there's a collective agreement in the company, but after 10, 15 years, the management is changed, the training reps are retired and replaced, and there is a collective agreement, and nobody knows what it exactly means. And then they can ask the conciliation board, maybe you can look to it. It's the selection of the joint committee, or in general the important spokespersons who are member of the Conciliation Bureau. And then there is a three-step approach. Of course, it's bipartite, half employer side, half trade union side. Of course, they can't be involved, can have an interest in the conflict. And then there's a kind of stepwise procedure. There's a first meeting, a first plenary session where everybody can make his point. Then the Bureau, this is the introduction. Then the Bureau goes separately and conciliates about it. Which also, it's a procedure with a lot of discussion. People go back to the backbenches, shuttle diplomacy, etc. And then at the end, there's a closing session where the conclusion is read out. And also sometimes the parties can make also a final conclusion. It's a very formal, arranged procedure, and that's important. There has to be some how to say that? It's like the king who invites somebody to. It's a bit comparable with the time of Karel the Grote. It's kind of really a board with some ceremony. That's the word I was looking for. The outcomes could be an agreement between the parties, a bureau recommendation, sometimes also with a follow-up, for example, to organize a referendum in the company. And also we have a so-called procès verbal of deficiency, non-conciliation. The President takes note that the current impossibility of reconciling the parties. But that sometimes also have already an impact. It can stopping or suspending actions, resuming dialogue. But also conclusions of non-conciliation, sometimes we see, that's why we don't have figures about success of conciliation bureaus, because sometimes a non-conciliation, we see that it was enough. People have better information, things are objectified, there is a kind of higher being heard, direct dialogue. So we're going to a lower level of escalation, and we see that afterwards the partners agree. Sometimes 1 hour after the bureau, sometimes 2 days after the bureau. So that's why we don't say it was successful or not, because sometimes there is success, but not at the end of the meeting. Again, here you can read what are important success factors. One of the issues is for the moment to have a management. We see now more and more international companies in Belgium. They don't have a local management, so that's already a problem, of course. Who you can invite. For example, Ryanair. That was one of the issues. It took some time to convince Ryanair about the Belgian traditions. So this, of course, is highly dependent on the unions and employees' organizations. It means, of course, has the national responsible people from the sectoral unions, do they have the authority to say to the rank and file, we have reached a compromise, we think this is how you have to look to the things, so this is our recommendation. So you have to have personality to do that, of course. And in your organization, you have to have a kind of authority and a natural authority. Then, of course, that's not successful. We have also individual missions of the conciliator. I will go not into detail because I think it's very comparable with what other people will say today. Of course, he has to willingness to listen and to negotiate, focus on win-win solutions, knowledge of the file, developing a balance of power. I think all the typical issues, I think, if you try to conciliate or mediate. And of course, using formal procedures, I think, is very important also when you conciliate. Then I make a comparison with the difference between conciliation and labor courts. I think you can read it. So I think it's important to have this framework and to ensure that discussion runs smoothly. That's the task of a social conciliator. But of course, you can lead the horse to the water, but you can't make him drink. That's a bit the principle of our Belgian conciliators. You can do an effort, but in the end, it's the social partners themselves that have to find a compromise. The only thing I still want to stress, of course, it's a Belgian system, especially this conciliation bureau, is a particular type. It can only work, of course, in a very embedded system. We have a very organized system of industrial relations in Belgium. We have a high organizational density. If the unions cover still 50% in the private sector membership. We have these official joint committees. We have also a hierarchy. We have a National Labour Council, a 2-yearly programming of collective agreements, largely legal extension of collective agreements, etc., etc. So it's a very organized system of industrial relations. And I think also important, it is based on a social pact after the Second World War, but it's based on also some essential process principles that are necessary for this type of conciliation, I think. First of all, the idea of autonomy of social parties. It's a very important principle in Belgium. For example, we asked the social parties now on the transition of the directive on adequate minimum wages. They provided a common advice on it. Then there is a rule in the government declaration that says we follow this common advice. That's a kind of the position of social parties in Belgium. It's still, but of course, I do now today a promotion talk. There are also some difficulties, etc. Okay, I will finish. And the second thing, of course, is autonomy, but also responsibility. And that's maybe more and more a problem. We give you autonomy as a state, as government, but it means you also have to be a responsibility. Conciliation Bureau, you have to take also the role. It's not to say when it's difficult, when there are conflicts, then it's the state, then it's the politicians. No. Also in the moment of when it's going difficult, when it's hard, when it's not easy, you also have to take your responsibility. The two things go together. Autonomy, responsibility. And the last point about is also, I think, we don't give it to everybody. Only to the most representative. You can articulate interest, but you also have to have the possibility to aggregate interests. The common interest of the country. That's also something that you have to have in mind. You can always cry, you can always, but at the end, the common interest. And that again, it's my promotion talk today. In practice, not always easy, of course, and that's why I will finish my presentation.
Ευχαριστώ τον κύριο Γκάι Βαν.
I would like to thank Mr. Guy Van Gaius. I believe he presented to us something that we already knew, that Belgium is a model of organization of social dialogue that is institutionalized and has a long tradition. It is a valuable experience for the other countries. Everything he said about the social dialogue was very useful. And, of course, based on what I understood, and correct me if I'm wrong, Belgium places particular emphasis on conciliation. And I believe that, given the new development, the latest developments, conciliation will play a critical role in the development of social dialogue. And that is why Belgium is a very good example. Now, we move to Bulgaria. National Institute for Conciliation and Arbitration, NICA, Mr. Vladimir Boyadiev. Did I say it correctly? Boyadiev.
Everyone. You can Greek names.
Yeah, it's okay. That's all.
Is it okay?
Yeah. Okay. You can put this one.
Okay, thank you. Dear Mr. Papadimitriou, dear colleagues, ladies and gentlemen, on behalf of the National Institute for Conciliation and Arbitration in Bulgaria, I would like to thank you for the invitation to take part in this conference and to be a speaker to present the activity and the status of the Institute. So it will be a short overview because almost in the report you can find out some particularity, some more deeper explanation. But following the thought that we have never future. Now? So, take into account that there is no future if you don't learn from our past and history. There is only few main points in our legislation coming from 1936 and finally comes to the creation of the National Institute for Conciliation and Arbitration. This is the point of voluntary out-of-court settlement of only collective labor disputes. In 1990, after the big tension during the at the beginning of the transition period, the experts were known in the field of labor law and social security law, Professor Sredko, with other Bulgarian experts, took part in a creation of the Collective Labor Dispute Settlement Act, which is the main law regarding to the settlement of collective labor dispute and for the National Institute for Conciliation and Arbitration. We have also, like other countries, together employers' organization and trade union made an effort to create independent NGO, but they did not succeed because, of course, of financial reason. The legal nature of National Institute for Conciliation and Arbitration is a little bit strange from the point of view of normal administration in Bulgaria. The law says that NICA is legal entity under the Ministry of Labor and Social Policy with the rank of an executive agency. And all this history is bind with the ILO support from various experts, but they help us to make a law of collective labor dispute settlement and also for create NICA. So the question is, as my previous statement, why not executive agency like employment agency, the general labor inspection, but the rank of executive agency? That's because the influence of the social partners. NICA has two-level government structure, the supervisory board by representative of the trade union and employers organization, and two representatives from the state on behalf of the Ministry of Labor and Social Policy. And actually, the supervisory board, who is I explained some of its function, has a crucial role to play. So, and the director is appointed by the minister after consultation with the supervisory board, and it's not the shame for me to answer to the question about the budget, staff, and all other facility. Why? And this is a crucial point. As you see, only $250,000 is the annual budget of the Institute in euro. But if you compare this amount to the probably cost of one-day strike, let's say in the city of Sofia transport, could you imagine how worth is it? And this is also maybe a measure or performance appraisal about the effectiveness of our institution. And also from the point of view of the taxpayer, to have an idea what is for this institute NICA. This is for prevent the losses in general society for the employer, for the employees, or for the workers, in case to engage by conciliation or arbitration or other, or something from its activity to prevent a strike. Let me go further. The point is that NICA was created by the social partners, supported, of course, by the state, to help the social partners settling the collective labor dispute on voluntary basis. The voluntary is crucial because it is the ILO is in the ILO recommendation. So, what the supervisory board do? No one but the supervisory board adopt rule for proceeding the conciliation / mediation. This is the same in Bulgaria, and arbitration. So there is no state who told to the NICA or to the to regulate from the power of the state. We should do conciliation and arbitration this way, without any general provision in the law, principal provision. And the supervisory board also adopt the criteria for selection and approval, the list of conciliator and arbitrators drawn up upon proposal of the organization of workers and employees. So our conciliators and arbitrators were proposed by the trade union representative and the employers on equal basis by some criteria to comply in some criteria made by the supervisory board, so made by themselves. And also the program of activity of the institute and the annual budget. Because there was a question about the role of the state in the process of conciliation and arbitration. The role of state reduced to, of course, as the director, I could say, creation of the institute, adopt a legislation, facilitate the voluntary settlement of collective labor dispute, nominated the representative, the representative from the state in the supervisory board, nominate the conciliators, mediators, and arbitrators, and appointed the director, also approved the budget and ensuring the facility for functioning. Main activities, conciliation, mediation. The name of the institute is National Institute for Conciliation, but the term conciliation does not exist in the law. voluntary arbitration, the special case of arbitration of minimum activity during the strike, and also we create and maintain the collective labor bargaining agreement information system, and as well the collective labor dispute database. Let me say something about the nature of dispute. In the law, we defined some way the nature of collective labor disputes. Not precisely, but in some way. We have not any power to be engaged to settle the individual labor dispute. There is a difference between other institutions who has this right. And also the law does not regulate the initiation of collective labor dispute by the employer. Only the workers send to the employer the written request and for, let's say, raise the wages or about the structure, about the employment issue, may initiate the collective labor dispute. So, who can apply? The precondition for the applying trade workers' party is to engage in a negotiation process, direct negotiation. And only parties of this dispute are entitled to apply to NICA for conciliation, for voluntary arbitration. For voluntary arbitration, they have to be joint request. And in case of arbitration, in case of minimum activity, each one of the parties may ask NICA to be engaged and to issue an award about the minimum activities. But as an institute, we have not right to initiate and to involve without the desire of the parties in a collective labor dispute. The procedure. It is deeper explained in a report, but let me say a few words. The conciliation, as I said, have appointed to the supervisory board of NICA according to the criteria. And by the proposal of trade union and employers, they have ethical code of conduct adopted by supervisory board, and the special case that all the procedure, how to perform the conciliation procedure, is done by the supervisory board in his rule for mediation and arbitration. The new provision from, there is no two years last, but allow to the director of NICA assign the conciliator to each specific case in comparison to the past time that every side can propose the mediator, the mediator. And this causes some tension who will be chosen and why. The payment. The payment for mediator before the changes in the rule from supervisory board were belong to the parties. And now the budget of NICA paid for their activities for only for 14 days in a sum equal to 1/2 of the average salary in a sector of professional activities. The arbitration, by law, the arbitrators have to be paid from the parties. In case of voluntary arbitration and in case of, let's say, compulsory, but the arbitration in case of establish minimum activity. But so the supervisory board can do anything in their own rules to change this, despite they desire to do this. The average amount is lump sum about €500 per arbitrator. The participation. Of course, voluntary means that if you don't participate, there is no sanction. But if you don't participate in a specific hearing, sittings of the arbitration body, who will defend your position? We have only one case that the employer refused to take part, and the thought was they avoid the arbitration award, but it's not the case. In every case, finally, especially in minimum activities, but also in voluntary arbitration, it will be an arbitration decision, award. While in mediation and conciliation, the result, the agreement, won't be ensured by the conciliator. So, the participation. So let me say finally, we have also very good design of our internet site, and everyone have access to all the database, all the legislation, also can apply. This is like using the new way of digitalization is very difficult to say. So because we are made by the social partners to them, to help them, we try to do everything that help the process of settlement, the collective labor dispute. Thank you.
Ευχαριστώ πολύ κύριε Βλαδίμηρ. Μας δώσετε και εσείς από τη δική σας σκοπιά.
Thank you very much for giving us your own approach to the respective organization on mediation and arbitration. I think that this is a good input for the discussion. The first session of the conference is coming to an end. I've got an idea. I am under the impression that because Europe places emphasis on social dialogue first and foremost, we will have to tell Europe to deal with conciliation, mediation. On the level of settling collective disputes, I don't think that Europe has gone very far. I think that today this is a good opportunity, all of us together exchanging views. Perhaps next step would be Europe promoting the idea of promoting the settlement of collective disputes. Are we going to have a discussion or will we break for coffee? I would suggest to have our coffee break now because we're very tired and then have a common discussion on both sessions. Okay, coffee break and then we will come back.
Καλώς ήρθατε στο δεύτερο τραπέζι της σημερινής μας εκδήλωσης.
Welcome to the second session of this event.
Τους οργανωτές της εκδήλωσης.
I thank Omed and the organizers for the invitation addressed to me to moderate this panel. I will switch to English in order to facilitate our foreign guests. I suppose most of us speak English and understand English, so
Να πω ότι πολύ σύντομα ότι
I dare say that my first experience from a mediation organization was from the US, where there is the National Mediation Board.
which is a very unique mediation board because it doesn't cover the whole industry. It covers only railways and airlines. It was created in 1934, and the reason for its creation was for the employers to be able to stop strikes throughout the mediation process. The mediation process is quite lengthy in those two industries under this legal scheme. However, history makes tricks, and since 1970s, 1980s, it is the other way around. Because the trade unions are in a weaker position, now it is the trade unions which use the mediation board in order to stop the employer from initiating layoffs, collective dismissals, etc., throughout the mediation procedure. It's a good example how legislation takes other forms from what you initially think. In any case, however, in both cases, it is the government's purpose to avoid strikes in railways and airlines, and that's the main reason for its existence. Now, I don't like, as a coordinator, to talk too much. I prefer our distinguished guests to talk. I have to say from the beginning that Mr. Ilya Manassiev will not be able to attend our meeting. I regret to say that Mr. Ilya Manassiev from the Northern Macedonian Association of Conciliators and Arbitrators will not be able to attend our meeting. So we will proceed with our other distinguished guests, starting from Ireland, Mrs. Silda Langford. I am glad that our table has overturned the balance of male domination from the first table. Now we have a more balanced synthesis. Now, you have the floor.
Thank you. Can everybody hear me okay? Louder? Okay, thank you. Okay now? Good, okay. Good afternoon, everybody. I'm honoured to be here to meet with you and present to you today and to hear from all of the other speakers. What has jumped out at me instantly is how, with very subtle differences, we are all using the same language in terms of conciliation, mediation and arbitration, but all mean slightly different things in terms of the context of our countries. So you'll find when I start speaking about those topics, it will mean something slightly different to what you know and what you've heard before. But before I do that, I just want to give you a little bit of background about where I'm from, because Irish people always assume that everybody knows who we are, and you don't. So we are a very small country in northwest of Europe. We have a population of just over 5 million. Our labour force is 2.8 million, and at the moment our unemployment rate is 4.2%. 16% of our workforce is in the public sector, and our trade union membership is recorded officially at about 22%, but in terms of other reporting, it can be as high as 34%. The majority of our trade union membership is actually in the public service, with over 60% of our public service being a member of a trade union. So just in terms of what I'm going to cover with you and the topics that were outlined, just putting them in a little bit of context for Ireland. I come from the Workplace Relations Commission, and I'm just going to talk about what it is that we do and why in a moment, who has access, how we resolve labour disputes, and we do it under 4 headings, 4.5 actually, because I'm going to introduce a new term, which is facilitation. So we resolve labour disputes through adjudication, mediation, conciliation, and then I want to very briefly mention our advisory service and why I think that's important. So, the Workplace Relations Commission is the single body of first instance for workplace relations complaints and disputes in Ireland. So what I mean by that is anything to do with work, it comes to the WRC first. So other countries have mentioned having different bodies here, we do everything. And then we have an appellant court, which is the Labour Court. We are an office of the Department of Enterprise, Trade and Employment, which would be your equivalent of Department of Labour's. All of our staff are civil servants, and we have a panel of adjudicators who are external, who I'll mention later. That's just our functions there, which I'm not proposing to go through, but these are our legislative requirements. We have a number of functions covering the full gamut from employment rights to industrial relations, individual disputes and collective disputes. We have a huge amount of employee protection in Ireland, similar to a lot of the countries here. Most of our legislation comes from the EU, and it covers employment equality, anti-discrimination, family-friendly measures, protection against unfair dismissal and victimisation, and then the right to information about working conditions. Our services can be divided into 4 categories, which is information, inspection, adjudication and voluntary alternative dispute resolution. And I'm only going to be talking about the bottom line today, because that's what we're here to talk about, which is the labour dispute aspect. So you can just see over there on the right that our voluntary alternative dispute resolution is broken down into conciliation, mediation, facilitation, and then our advisory services. Our overarching vision and our mission within the WRC is to deliver a world-class, impartial, fast, effective, high-quality service to all of our customers. So that's employers and employees. In terms of who has access to the WRC, it comes down to legislation, which is in relation to employment rights. All workers have access to the WRC. In terms of employment equality, the same applies. In terms of industrial relations, it is limited to employees who are not civil servants or teachers. And then we also have a function which has absolutely nothing to do with employment and has to do with equality, and that's for access to services, which I'm not going to be talking about today. But if I could sum up how the WRC does labour dispute resolution, it would be in this graph. So I can divide it down into 2. We have individual dispute resolution and we have collective dispute resolution. And then within both of those categories, we have rights-based dispute resolution and interests-based dispute resolution, with ultimately everything ending up in the Labour Court as the court of last resort. Issues at the Labour Court can be referred to our Judicial High Court, but only on a point of law. A dispute cannot go to the High Court. It is literally in terms of how the law was interpreted. So, I'm going to talk briefly about our adjudication services first. I think it's a topic that hasn't been covered yet this morning, and it would be similar to what others have described in terms of arbitrators. But our adjudication services do 2 things. They do employment rights and they do industrial relations. The key difference between the 2 is when it comes to a decision about an individual who has an employment or equality right dispute. That is a legally binding decision made by an adjudicator, but if it relates to an interests-based dispute, it is a recommendation only. And if it's an interest-based dispute, it can only go to an adjudication officer if the employer agrees that that can happen. So in relation to the law, it's a legally binding decision, but in relation to industrial relations, it's a recommendation. So first, both parties have to agree to attend, and then any recommendation that is issued is non-binding on either party. And that can be referred to the Labour Court for a final recommendation, which is also non-binding on either party. So all industrial relations in Ireland is voluntary and non-binding. Decisions for employment rights and equality complaints have a very legalistic structure. I won't go into the detail there, but it is very much an environment that involves the legal profession, which I think somebody made reference to earlier. The WRC would be of the view that anybody can access our services at any time without representation, either from the legal profession or from the trade union movement, but it's not required, and the same applies to employers. So they can be represented or they can represent themselves. All of our services are free. There are no fees required to be paid. Where mediation then comes into the mix, which is why I mentioned adjudication, is that the mediation that we provide in Ireland happens before an adjudication hearing, so before you get into the legal aspect of any case. Mediation is provided for in our legislation. It is a statutory function, but again, it is a completely voluntary process. So mediation only goes ahead when both the employee and the employer have agreed to it. But where we find mediation extremely successful is that voluntary nature, in the fact that the parties come together, they reach a solution together. The mediator facilitates that solution. Anything that is reached by agreement is written in a legally binding document signed by both parties, and the contents of that document are completely confidential. So in our experience, it's an extremely attractive service because people can come to mediation, they can resolve the issue, they can put anything they like in that document as long as both parties agree to it, and then it goes away. So it's completely confidential. Whereas the alternative is it will go to a hearing, and that hearing is in public. So it can be reported on during the hearing, and then the decision from the hearing is published. As everybody knows, employment cases are extremely interesting, so journalists love a good story. So mediation is very attractive to people from that perspective. This is the new piece of legislation that got brought in 2015, and it continues to grow for us every year as more and more parties realise that engaging in a voluntary process that they have full control over is a much better outcome for everybody, rather than heading to an adjudicator who is essentially a lay judge who makes a legally binding decision. That is just some further information about it. As I mentioned, it's completely confidential, it's voluntary, it's legally binding, it's impartial, and it's completely flexible and informal. Where a mediation like this doesn't function is if the issue is in relation to an individual trade dispute. So again, because a trade dispute is voluntary, you can't have a legally binding outcome in Ireland. So we can't have a legally binding document for something that is a voluntary process. So we don't operate mediation for industrial relations. Just going to skip over that. So in terms of how people have access to our services from a legal rights and equality perspective, it is the employee who accesses the WRC. They indicate at that time if they'd be prepared to engage in mediation before going to a hearing. And if so, we contact the employer and ask them if they would like to come in and engage in mediation. And if they do, we'll go ahead and do that and try to resolve it at that point. We also give access to the employer, even if an employee has not identified that they'd like to do mediation. If an employer asks us, if they say we have been put on notice of this complaint, we'd like to engage in mediation, we will try our best to facilitate that. We will contact the employee, see if we can resolve it, again, in a voluntary nature and in a completely confidential nature. So that there are how we resolve individual disputes at the WRC. Then our conciliation services are very similar to ones that we heard from today, and I think in particular from Belgium. Our conciliation services is collective bargaining. In Ireland, we have a completely voluntary system. It is based on good faith bargaining. There is no binding aspect to it. Nobody can be compelled to engage in collective bargaining. We have constitutional rights in relation to the right to form associations and unions. So our constitution says that you have the right to join a union, but the converse of that is that you also have a right not to join a union. So the rights are qualified by law, and while everybody has a right to be in a union, they do not have a right to be recognised for collective bargaining. So the voluntary aspect for the employers kicks in there, which is an employer has to agree to recognise a workforce to collectively bargain with. So somebody working in a company can be a member of a trade union, but that trade union does not have a recognised right to negotiate on their part. In terms of how we engage in collective bargaining, so we do have a level of sectoral bargaining, and in particular you'll see I mentioned construction, electrical engineering and mechanical engineering there, so that applies to the whole sector, and they are registered collective agreements that cover pay, pensions and sick leave. We also have sectoral bargaining for our public sector and public administration, but there is no legally binding element to that at all. It is a completely voluntary process. When we are engaging in collective bargaining with disputes of interests, it is always groups of workers. They relate to matters that do not involve legal rights. So if there's a legal rights issue, in Ireland it can only be done on an individual basis. So for example, if you have a group of workers who have a legal rights issue, each member of that group has to register their own identical complaint for it to proceed through a legal forum. But in collective negotiation, they're represented by their trade union, and it's talking about terms and conditions of employment. It's based on what's regarded as fair and reasonable, and it's nearly always in relation to pay or improved terms and conditions. So as I mentioned, it's trade disputes for collective bargaining. It's provided for in legislation, but again, the legislation just provides a framework for engagement. It doesn't actually give anybody any rights. It just puts the rules in place. We have an 85% success rate in terms of our conciliation service, with the other 15% being referred to the Labour Court for as the court of last resort for a recommendation. We facilitate both public sector and private sector disputes, and our service is based completely on fairness, impartiality and independence. It is the reason that we are structured the way that we are. I think there was some discussion here this morning in relation to that if we do not have our independence and our impartiality and our fairness, then our service will not be used, which is the nature of a voluntary service. If parties don't have trust in the conciliator and in the WRC, then we won't be able to deliver a service because they won't come to us as a voluntary basis. So we take great pride in that independence and impartiality. So the process for engaging in a collective dispute in Ireland is local engagement in the first instance, ideally resolving it at a local level, and if that's not possible, it comes to the Workplace Relations Commission for conciliation. We'll resolve it 85% of the time, and then if not, it'll go on to the Labour Court. But again, just to clarify, any decision from the Labour Court is a recommendation that has to be accepted by both sides. So there is the option for either side or both sides to decide that they don't agree with the Labour Court recommendation. But then, I think somebody mentioned gentleman's agreement here this morning. The question for the parties is, where do you go from there? You have been in a dispute, maybe you've been on strike or you're thinking about going on strike, you've been through an intensive negotiation process, you go to the Labour Court. Most parties accept the decision on the basis that the dispute has to end somewhere. On occasion, parties will reject a decision. It's extremely unusual. It's more likely to be the trade union because they will ballot on the recommendation from the Labour Court. And at that point then often you might see trade unions engaging in strikes, but again it is extremely unusual. In terms of the type of disputes that we cover, we divide them into 7 categories. So it's pay related, organisational structure, so we like hours of work, rosters, restructuring, redundancy, pensions, leave entitlements, any benefits in addition to those, and then everything else we classify as an industrial relations issue, so whatever other nebulous items fall into that. And just to give you an idea of the breakdown there in 2022, you can see most of our disputes related to pay or organisational structure, and that would be pretty standard. In a nutshell, that are the services that we provide. The last service I just wanted to mention is our advisory service, which is provided for under legislation. So we have a role in ensuring industrial peace in a generality. And we do that through our advisory service. So, for example, if we have regular service users for industrial disputes, so if we have a company or a group of workers who we find are regularly coming in for conciliation, our conciliation officers might refer them to our advisory service, who will go in and do a full audit of the company and the social partners, put a framework in place in terms of how they can improve their industrial relations, and then hopefully minimise the service or the disputes going into the future. Or parties can self-refer. So maybe a trade union and an employer has identified that they need to do some work together in terms of social partnership, and they will contact us. So the items that we cover for advisory services are industrial relations reviews, like I just mentioned. We provide training by request. We conduct research on behalf of the state and for the WRC. And then we're also responsible for codes of practice. So we have a number of codes of practice that provide guidelines. They're not legally binding, but they provide guidelines to both workers and employers in terms of how certain business would be conducted. For example, we very recently published a code of practice in relation to accessing remote working and flexible working within the workplace. So this gives steps on how the best way to go about doing that. So in the round, that is our complement of services in terms of resolving labour disputes. Who does that? The vast majority of our staff are civil servants. The civil servants provide telephone mediation services. They are industrial relations officers. That is our team of staff who do collective disputes. That's our conciliation service. And then we have a group of civil servants who are also adjudication officers. In addition to that, we have an external panel, which I think has been a feature here today and will continue to be, of professional practitioners in industry who are recruited and appointed on 5-year terms, and they provide contracts of service, who also deliver the same service as adjudication officers. In a more flexible manner, if I can put it like that. So some of them work part-time. They might do 1 day a week, 1 day a month. They might do 3 days a week. So we use both of those groups of workers to provide our service so that we can, I suppose, scale up and scale down depending on the demand. And then our mediation services are dual cap wearers. I think you mentioned that earlier. So it is our conciliators and our internal adjudication officers who provide our legally binding mediation services. In terms of our stakeholder engagement, we do tailored outreach for different stakeholders that can be industry based, or we do national campaigns also, where we engage in consultation processes on a sectoral level, on a topical level, and then with various stakeholders. We do regular customer surveys, and by customer surveys, service users, so trade unions, employer representative groups. Most individuals who are coming to the WRC, hopefully for them, they will only engage with us once. That's the ideal outcome, so we wouldn't necessarily consider them customers. And then in terms of developing our codes of practice, we engage in social dialogue in terms of the development of those. So they're made in conjunction with all of the social partners. So that is our full suite of services. Thank you very much for your time this morning. I think I stuck within my 20 minutes.
Thank you, Mrs. Langford. Thank you, first of all, for your time management. And may I remind some points that have in my mind from what you said. Your emphasis in the non-mandatory, the voluntary aspect of these processes. The fact that you are significantly involved in individual resolution of individual disputes. This is not the case in other organizations, certainly not in Greece, unless there is one exception. I was impressed by the 85% ratio of success of the conciliation process. I think that we have, in the 20 minutes, you have put many interesting things in a very few words. and we appreciate that. You mentioned the labor courts. At some other point, at some other venue, maybe we should discuss the difference between the labor courts in various European countries, their composition, their authority, their functioning, etc., etc., but not in this venue. Now, following the program, we turn our attention to Mrs. Alexandra Silva, who is coming from Portugal, and she's working in the General Directorate for Employment Relations and Industrial Relations, for Employment and Industrial Relations. Thank you, Ms. Silva.
Good afternoon. I'd like to start by thanking Omed and Professor Kostas Papadimitriou for the kind invitation to take part at this conference. It is indeed a great pleasure. So, in Portugal, we have 3 types of extrajudicial mechanisms for settling collective labor disputes: conciliation, mediation, and arbitration. I'll talk to you about each one of them. But first, let me tell you that one of the organizations that carries out conciliation and mediation of collective labor disputes is the Directorate General for Employment and Industrial Relations. From now on, I call it GERT, so it's the short name, it's easier to say. Although labor legislation allows the parties to choose a private third party as conciliator or mediator, in reality this option is never used, so it's GERT the one who conciliates. It is a public service of the Central State Administration and the Ministry of Labour, Solidarity and Social Security. Therefore, there is no involvement of employers, organizations or trade unions in its operation. GERT has administrative autonomy, but no financial autonomy. Its funding is mostly ensured by the appropriations provided for in the state budget. Nevertheless, I can say that conciliation and mediation services operate without government interference. GERT is headed by a Director General who is assisted by a Deputy Director General, both of them appointed by the Secretary of State for Labor. So its main offices are located in Lisbon, the capital, but the conciliation services have premises both in Lisbon and in Porto. I'm from Porto, so you know which is the best city, but Lisbon services cover the Lisbon metropolitan area and the south of the country, and in Porto we deal with the north and center regions. So regarding the conciliators, I have conciliators/mediation because mediators, because I will explain later. For us, it is 2 different concepts. But as I was saying, our conciliators are full-time civil servants. They all have university degrees, and most conciliators have attended the ILO certification course in conciliation mediation of labor disputes, and they obtained the corresponding certification. Only the 2 most recent conciliators don't have this attended this course yet. We have also attended, all of us, other training courses on settling collective labor disputes, all of them organized by the ILO. So we have no specific code of conduct for conciliations and mediators, but GERT has a code of ethics and conduct for all employees, which establishes some principles that should guide the work of conciliators and mediators. These are the principles of independence and neutrality, impartiality, confidentiality, and professionalism. As I have already mentioned, GERT deals with collective disputes. It doesn't deal with individual disputes. We deal both with rights dispute, the violation of an existing entitlement embodied in the law or in a collective agreement, and interest disputes that concern the establishment of future rights and working conditions. Usually, what is at stake is a breakdown in the negotiation process for the conclusion or the revision of a collective agreement. As far as conflicted entities are concerned, CHERT promotes the conciliation and mediation of collective labor disputes in the private sector, while another public service, the Director General for Administration and Public Employment, is responsible for resolving collective disputes in the public sector. As we'll see later on, CHERT does not initiate conciliation or mediation procedures on its own. We only do that at request of the parties, one or both, we'll see, but it's always at request. So, moving on to the procedures. The mechanisms promoted by the CHERT when the dispute relates to the conclusion or revision of a collective agreement, interest disputes, are conciliation and mediation. We know that in some countries these two terms are used interchangeably, but as I told you before, in Portugal they correspond to different procedures. So at this stage, I must explain that the Portuguese Constitution exclusively grants trade unions the right to collective bargaining on behalf of workers. So on the employer side, both employer associations and the employer itself, alone or jointly with other employers, have the capacity to conclude collective agreements. Therefore, both trade unions, employers association and employers can request a conciliation procedure and be parts in it. It's important to say that conciliation is free of charge, as are all procedures promoted by CHERT. They are all free of charge. Conciliation is conducted by an independent and impartial third party, the conciliation, with the aim of facilitating negotiation between the parties and helping them to reach an agreement. It is a voluntary mechanism, both in terms of its beginning. The parts are not obliged by law to request conciliation in order to resolve the conflict, and in terms of its outcome, because the conciliator cannot impose a solution and the parts are not obliged to reach an agreement. Nevertheless, the parties have duties. They must attend meetings they have been called to, and they have to act in good faith. That's what our labor code states. The unjustified absence of either party from a conciliation meeting summoned by CHERT constitutes a labor administrative infraction, and it is punishable with a fine. So we used to say they have to go. What they will do there, we don't know, but they have to go. The parties can establish the procedural regime for conciliation within the framework of a collective agreement, or they can do an independent agreement. But if it is not the case, then the procedural regime laid down in the Labour Code applies. In reality, despite the supplementary nature of the legal regime, it turns out to be the rule, because the parties never do it regulate it in the collective agreements or have any agreement about the procedure. So, the Labour Code stipulates that conciliation can take place at any time by agreement of the parties or at request of only one party. But in case it is only one party, the one that requests it, they have to give an 8 days written notice to the other party, or they don't have to give written notice when the situation is of absence of response to the proposal to conclude or to revise a collective agreement. The law states that this response has to be given in a 30 days period from the proposal. So if the other party doesn't even respond, there is no written notice necessary in order to request conciliation. As a rule, meetings are held in person, as we believe that they provide a better environment and conditions for dialogue than remote meetings. However, at the request of the parties and given specific circumstances, they can be held remotely by Microsoft Teams or Zoom. This was a change the pandemic brought us, and I believe in all countries it changed for you too. The conciliation must draw up minutes of each meeting held, summarizing what happened during the meetings, and these minutes must be signed by all the participants. So if the parties reach a full consensus or if dialogue is reestablished and they decide to return to direct negotiations, then the conciliation process obviously ends. But otherwise, it is up to the conciliator to decide when to end the conciliation. What I'm trying to say is that the labor code does not establish a minimum or maximum time limit for the conciliation. So it is understood that conciliation should last as long as it is still possible to reach an understanding between the parties, even though we think it's difficult to achieve, but if there is still some hope, we'll go on trying to get them to reach agreement. So if an agreement is reached, the conciliator must specify its terms in the meetings. However, the minutes do not have legal value of a collective agreement. In order to become a collective agreement, it must be formalized in an autonomous document and signed by the representatives of the party, and then it must be deposited in the Ministry of Labour and published in the official journal. Now, moving on to conciliation, I'll start by pointing out that it has several points in common with conciliation. So mediation is applicable when the issue is the conclusion or revision of a collective agreement. It is also a voluntary procedure. The parties are not obliged by law to request it or to accept the solution proposed. It is free of charge, and the parties can establish the procedural regime for mediation. Where there is not the case, the regime laid down in the Labour Code applies. So what distinguishes conciliation from mediation? In the conciliator's role is to facilitate contact between the parties, helping them to explore alternatives and reach a solution to the dispute. However, it is not up to the conciliator to present a specific solution to the parties. In mediation, on the other hand, the mediator takes a more active role, and he is responsible for presenting in writing a concrete proposal for a solution, which each party is free to accept or to reject. As with conciliation, if both parties agree, they can request mediation at any time. However, if there is no agreement, mediation can only take place if a conciliation procedure has been carried out beforehand. If the conciliation procedure is still ongoing, it can only be converted into a mediation 1 month after its beginning. So the request for mediation must be analyzed within 10 days of its submission, and once its regularity has been confirmed, the mediator is appointed. The mediator can ask the parties and any government department for the data and information he needs to draw up the mediation proposal, and he can also meet with each of the parties, not only to obtain information and get to know them, the party's position, but also to understand which issues each party can compromise on, or on the contrary, is inflexible about. So it's what we call the red lines. What are your red lines? Where can you go to? In mediation, we don't have joint meetings. The mediator also only talks separately with each party. Within 30 days of his appointment, the mediator must present a mediation proposal to the parties, and the parties then have 10 days to say if they accept that proposal or not. And once the replies have been received, or after the 10 days period has expired, because sometimes the parties don't answer, the mediator has 2 days to communicate them whether the proposal has been accepted or rejected. It is important to note that, same as conciliation, if the proposal is accepted by both parties, they still have to formalize it in a separate document signed by the representatives, which is then deposited in the Minister of Labour and published in the official journal. So, let's move on to another kind of conciliation. It's a mechanism called as collective dispute prevention or resolution, which applies when we are dealing with rights disputes. Shared action in this area stems from its organic law, since the Labour Code does not contain any specific provisions on the conciliation of rights disputes. Disputes prevention may be requested at any time. There's no need for written notice to the other parties, and it may be requested not only by trade unions, but also by other structures representing the workers, such as workers' committees, trade union committees, or inter-union committees. Although it is not usual, it may also be requested by employers, and it is not usual, but it happens when they have a conflict within their companies and they ask for our help to try to solve it because they believe they can't talk directly with the trade unions or the workers' representatives. So it has voluntary nature, since the parties are free to decide whether to apply to the proceeding or not. As with conciliation, in disputes prevention, the conciliator adopts an independent and impartial position with the aim of opening up or improving the dialogue between the parties so that together they can explore possible solutions and reach an agreement that will allow them to overcome the conflict. If an agreement is reached, the mediator must indicate its terms in the minutes of the meeting. However, this agreement has not enforceable legal value. So, although it can't always be taken into account by a court of law. This procedure is also free of charge. You can see now the difference between these three procedures. There is another extrajudicial mechanism for collective labor disputes that concerns the dispute over minimum services during strikes. In this case, CERT is responsible for the negotiation of minimum services when the companies meet essential social needs. If the parties do not reach an agreement, then there will be a decision either from the Ministry of Labour or, in case of a company from the corporate governance sector, by an arbitral court. To give you a slight idea of the weight of each mechanism in CERT's activity, I brought you some data concerning 2022. And you can see that 45% of procedures promoted were for conflict prevention rights disputes, followed by the negotiation of minimum services and conciliation stricto sensu. So, I will not now talk to you about arbitration, but I would like you to note that, as we'll see below, arbitration is not within CERT's scope. Despite of that, I will try to describe you the mechanism, the mechanism's basic guidelines. We have all kind of arbitrations process. As you can see, we have voluntary arbitration, compulsory, necessary, arbitration to define minimum service, and these two, I put it in there. They are new, they are really new, and I believe they have never been requested because they were introduced by the law 2023 law that made big changes in the labor law, Portuguese labor law. I will only talk to you slightly about voluntary, the three first types of arbitration. But I would like to point out that the use of arbitration in Portugal has been very residual. I wrote in there it's almost non-existent because indeed it is. The only exception is for the arbitration for minimum services because those are always increasing. We have lots of strikes in the health sector, the hospitals, they are all in the government scope, so it's a court of arbitration that defines the minimum services when there is no agreement on the minimum services. As you can see, for almost 20 years, we have had 5 arbitration awards. One voluntary arbitration in 2005, one of the biggest Portuguese bank, but I can tell you that this voluntary arbitration was partial because the parties reached an agreement at the majority of the causes, and then they were fighting over half a dozen of issues. Thank you. English is not my language, so thank you so much. Yes, native language. So it was one voluntary arbitration award and 3 decisions in compulsory arbitration procedures. I talked to you about 5 decisions because one of these was revised in 2012. One of our courts, higher courts, decided it had to be reviewed, and it was a following decision. So there are common rules concerning arbitration awards in voluntary, compulsory, and mandatory arbitration. They must obey the same rules that apply to collective agreements regarding their mandatory content, their limits, and the need to be deposited and published. Otherwise, they have the same effect as the collective agreement. In voluntary arbitration, the use of arbitration can be either provided for in advance in a collective labor agreement or other contractual document, or it can be decided by the parties at the time the conflict arises. We have a law, the voluntary arbitration law, that provides for supplementary rules, and I give you there 2 examples regarding the formation of the arbitration court and the possibility for them to be assisted by experts. The arbitration award must be taken by majority vote. Unless agreed otherwise, it must state the distribution of the costs resulting from the process, and the decision cannot be appealed unless it is expressly provided for by the parties in the arbitration convention. Then we have the other 2 types of arbitration, mandatory arbitration and necessary arbitration. In mandatory arbitration, the Minister of Labour may order it in the following solutions. when, being the first agreement, there is no agreement, collective agreement for that sector. It is requested by any of the parties as a result of an unsuccessful negotiation, and provided that it is not possible to settle the dispute by any other mechanism, voluntary arbitration or conciliation or mediation, due to bad faith of the other party. Of course, bad faith is a difficult concept to find out, but it is what the law says. It can also be determined on the recommendation of the Social Consultation Standing Committee, and on its own initiative, the Minister of Labour, after hearing this standing committee, when the services in question are indispensable to the protection of people's lives, health, or safety. This standing committee is made up of representatives from the government and from the social partners. So with regard to the social partners' role, we can see that this SESC either takes the initiative, or at least it must be heard before mandatory arbitration is determined. Moving on to necessary arbitration. This mechanism was designed to fill a gap in the collective bargaining system. It has around 12 years, I believe, but as you've seen before, there is no necessary arbitration award, so it hasn't been much successful. This necessary arbitration is determined by ministerial decree when a collective agreement applicable in a given company, business universe, or sector of activity expired, and there has not been a new agreement in the following 12 months. Also, when there is no agreement applicable to at least 50% of the workers in the same company, and either party requests the opening of arbitration proceedings. So these three requisites, I don't know if I say that, have to be, they are cumulative, they have all to be present. Then we have some common rules some rules that are common to mandatory and necessary arbitration. I don't know if I'm taking too long. I believe so. Yes, so I'll move on. I had brought you some appointments regarding the labor mediation system, but I will not talk about it. It is a system to resolve individual conflicts, but it has almost no expression in our country. As you can see, the numbers are very, very short. It doesn't have any adherence. So thank you for listening to me. I'm sorry for getting over my time, but thank you.
Thank you, Mrs. Silva. I was a little bit flexible because our colleague from Serbia has promised he will not exceed the time, so we are okay. We appreciate your description of the different procedures, according to what kind of dispute we have and according what kind of conciliation, mediation, arbitration we have. I am wondering, but maybe we can leave it for the discussion afterwards, whether in the history this mandatory arbitration ordered by the ministry has been ordered or it's just in theory in the law and has not been applied. And I also note with interest that the disputes in the public sector are handled by another agency, by another directorate, general directorate. Actually, in Greece, we don't have organized disputes, resolution and collective bargaining, etc., although it's in the law. So we have now the pleasure to listen to our colleague from Serbia, Mr. Ivica Lazovic, who is from the Serbian Agency for Peaceful Settlement of Labor Disputes. Mr. Lazowitz.
Hello, everybody. First of all, I would like to greet all the participants of the conference and express my personal satisfaction that for the first time I will be presenting in English. I'm particularly pleased to be speaking Athens, which is the root of European civilization. One more information. My English is not really good, but I hope you will stay here until the end of my speech. But don't worry, I have very short speech. So, I will stick to structure and format proposed by our organizer. The Republic Agency for Peaceful Settlement of Labor Dispute in the Republic of Serbia is part of the public sector, organized as a separate organization. Next year, we celebrate 20 years of our work and existence. The agency is independent body. The agency is direct budget beneficiary. The total annual budget in the agency for 2024 is 216,000 euros. The agency is responsible for individual and collective labor dispute. In individual dispute, employees and employers can lead dispute regarding various types of payments and also regarding work harassment and discrimination. Collective labor disputes are concluded before the conciliation committee, which forms a conciliator, union representative, and employer representative. The most common reason for initiating this type of procedure relates to collective agreement, its conclusion, change, and implementation, as well the position of the trade union itself. In activities in which there is an obligation in ensure a minimum work process, the agency has the authority to initiate processing ex officio. The agency submits an annual report on its work on the Social and Economic Council, which members are the social partners. Also, social partners are members of Commission, the selection conciliators and arbitrators, and agency does have a representative in the Commission. The director is professional civil servant in a position that is selection through a competition. The director's mandate lasts 5 years and appointed by government. The agency uses premise in the center of Belgrade. The procedure before the agency is initiated by proposal. The procedure is voluntary. When the other party agree, the arbiter or conciliator takes over the case, schedules hearings, and issues an arbitration decision or recommendation. The procedure is free of charge for the parties to dispute, and the reward for the work of conciliator and arbitrator is paid from budget funds. In order for arbitration by valid, it's necessary that the principle of voluntariness is respected as the basic principle of procedure. In the Republic of Serbia, arbitration is a single-stage procedure, and there is not possible appealing the arbitrator's decision, which has a force of res judicata. The conciliator's recommendation is not binding. Discussion in the proceeding are held in accordance with the dynamic agreed by the parties. The presence of the parties in the arbitration proceeding is necessary. When it comes to collective dispute, the presence of board members is necessary. The agency does not have authority to monitor the implementation of the decision made. Arbitrators and conciliators are chosen in public competition for aiming experts in labor law. Their mandate lasts for a year. They are not employed by the agency. They are obligated in accordance with the law and the code of ethics to be independent and impartial in relation the parties in dispute in the processing. With the help in the International Labour Organization and the German Organization for International Cooperation, GIZ, several training sessions we are organized for conciliator and arbitrators. Also, we participate together in various conferences, seminars, and round tables, and the communication strategy for the agency was create everything in order to bring in the Institute of Peaceful Resolution of Labor Dispute closer to citizen. As part of ILO and GI's project, the agency delegation also visited the FMCS in America. And finally, I would like to emphasize the great importance of this conference, which has brought together organizations from all over Europe, aiming to resolve labor dispute in peaceful, alternative manner. I hold great optimism that conference will have a significant impact on consolidating of us, exchange best practice, and fostering mutual development. And especially, I thank the organizer, Professor Kostas, for the opportunity to speak and participate today. This short version, but long version is in paper after conference. Thank you for attention.
Thank you, Mr. Lazovic. Given your kind words about Greece at the beginning of your speech, I was willing to give you an extra 20 minutes, but it's okay. You're the president of the first country in our today's meetings that is not member of the European Union, but I can see that you have quite similar dilemmas, and to some extent you give similar answers. Good work with your future work. Now, I think we have enough time to make a fruitful discussion pertaining to both tables, this morning's and this one. So let me see hands before I give to each one the floor. See how many people are interested. 1, 2, 3, 4. The people that I know of will not take the floor. So we have 4 till now. I suppose that when the first floor speaks, some will think of taking the floor. So let's begin. Yes. Please state your name and your country. And
Good morning. This is Eva Ruiz from CIMA, from Spain. I wanted just to say that I firmly agree with Professor Servais in the first round, who spoke about a transnational system that could be interesting for transnational conflicts, because we have had a few of them in Spain, and the parties that comes to the mediation aren't allowed to transaction, so they just come to CIMA for complement internal formalities in Spain. So they don't really participate in any negotiation. They come, they complement the mediation, and that's it. And I think that this kind of disputes could be solved by mediation as well, or conciliation, of course. But there should be an organism that takes care and that calls the right people to be seated in that tables. Thank you.
Καλησπέρα. Good afternoon. I am Athina Malacharti from Greece. I would like to make a commentary to the previous panel. The representative of Belgium and the representative of the General Confederation of Workers, Mr. Drakopoulou, talked about the European Directive 2022-241 for a minimum wage that Greece is going to incorporate in November. November is the end date for integrating this directive into Greek law. As both gentlemen mentioned, this directive says that member states that do not have coverage up to 80% will have to draft a national action plan, a roadmap to cover this rate up to 80%. In 2006, Greece had a coverage of 82%. Then we had the financial crisis, as we all know, and we reached to the historic low in 2014, 15%, which is 65% less in the coverage of collective agreements. Now we are at 24 to 29%. So we have a long way to go from 30% to 80% of the European target, which is 50 percentile units. I saw that Belgium has 2,500 sector-wide agreements, and they sign one every 2 years. In Greece, we have 32 sector-wide agreements. So we need to pay attention, great attention now in the future, in designing the future, to cover this rate that collective agreements have to cover. I have a question to the Belgian representative, perhaps to Mr. Kouliadis, who was the designer of the act and the president of the OMED. What do you think are the most important factors to increase this cover ratio? Belgium already mentioned that they have a very well-structured system of labor relations. They mentioned the huge value of reinforced social dialogue. What other factors do have to be there? Because Greece needs to go by leaps in order to, needs to proceed by leaps in order to cover the gap. And another commentary to the ILO. We have remarkable colleagues here. Me and the ILO team in 2020 with the social partners, we drafted a report precisely on that. Individual and collective disputes, a comparative survey by Belgium, France, UK, Spain, Australia, Sweden, Greece. Greece was dealt with by Mr. Kouliadis. Those of you who are interested, because we have students with us, they can go into the ILO's site where they can find this comparative study both in English and in Greece on labor dispute settlement in the countries I mentioned. Thank you very much.
Ενδεχομένως και εκπρόσωπος της Ιρλανδίας θα ήθελε να σχολιάσει το πώς μπορεί να ανέβει το ποσοστό κάλυψης. 22% έχω σημειώσει ότι είναι... Κύριε Αγγελοπούλου.
Mrs. Αγγελοπούλου.
Ναι, καλημέρα σας. Γεια σας. Πρώτα απ' όλα θα ήθελα να ευχαριστήσω.
Good day. I am Olga Angelopoulou. I am mediator in the organization of mediation and arbitration in Greece. First of all, let me thank you warmly, all the presentators, the speakers, for the very interesting presentations where they present their own systems and offer us food for thought, shedding light to our own questions. I have this question to you. One question to the Belgian representative who mentioned their very well organized Belgian system. He said, if I understood correctly, that it is employers who state at which bureau they belong. Their participation there is mandatory by law, or do they do it because of this well-structured organization? Or the good records of their organization? This is one question. The other question is to the representatives of Ireland and Portugal, merely because you mentioned the part of bargaining, mediation and conciliation for minimum service in case of strike. This is a source of a lot of worry in Greece and a lot of reflection because, to state it simply, until recently the Greek legislator had not adopted any rules. And it was the social partners that freely agreed which needs had to be covered minimally. But with recent legislation, the situation is more rigid. So now there is a specific rate that has to be filled in, 1/3. And this rule about the minimum creates many issues about restrictions of liberty. Do you have any similar regulations in your countries? And has there been a way to settle this issue that might be helpful for our own situation? Thank you very much. Thank you, Mrs. Angelopoulou. I think we have a fourth question.
It's not a question, it's an answer. I don't know. I could speak like this.
It will not be easy for the translators.
Yes, it's an answer to the question here. I take the example of France. France has a very low level of collective agreements and trade union rates. Nevertheless, the coverage of collective agreement is very high. Why? Because there is a special procedure of extension of the collective agreements made by the government at the request of the parties, and that permits to cover most sectors in France. So it's a very technical issue, but it helps a lot in the progress of negotiation. As I have the floor, I will also mention something. There are some fields in which really the European legislation could be improved. For one example is the way to, to recognize the trade unions. I remember to have had discussion with representatives of multinationals working in the European Union, saying the Committee of Enterprises are really very difficult to implement. Why? Because the representation system varies from one country to the other, and to have the reflection of that at the committee level is extremely chaotic, let us say. Thank you.
Ευχαριστώ πολύ. Ονομάζομαι...
Thank you. I am Sofia Kazakou, legal advisor to the General Confederate of Greek Workers and representative of it at the board of OMED. I heard very attentively the presentations, some remotely because of my busy schedule and some in person. Let me start with what Mrs. Athina Malagardi said, the need to increase the coverage ratio of collective agreements. What happened in recent years and led to this swift drop in coverage was a series of legislative interventions, among which the removal of the possibility to decide about minimum wage by the General Confederation of Workers. The General Confederation, in the collective agreement signed with the employers in the past, used to regulate these minimum wage terms. And this was generally applicable throughout the country. And this was helpful in having a quite large coverage rate. This competence was taken by the government, so we have a big lag. But this is not the only reason. It is also the inability of having collective arrangements. And responsible for that is the institutional framework in which OMED needs to function. I heard that at the center of almost presentations is the voluntary component in the settlement of disputes. But how does that work? We need to understand this. I understand the voluntary dimension in a conciliation, in a mediation procedure. However, in arbitration, which is the last resort where we need to come down to some kind of rule, how can the voluntary element work when one party does not want or it's not to their interest to have a collective agreement? In Greece, the answer has been given by the Supreme Courts. The plenary session of the Supreme Administrative Court and the Supreme Civil Court ruled that it is compatible with our constitution. And in fact, the constitution tells the Greek legislator to ensure arbitration proceedings that are independent of the will of the parties, because it is the only mechanism that can lead to the signing of collective arrangements. Therefore, what's the scope for freedom, which is the leitmotif of the employers' associations? They say that our freedom is restricted, our freedom to sign a collective agreement. But what type of freedom are we talking about when this is not a freedom between equal parties, but between unequal parties? In Greece, the bargaining power of trade unions is relatively low. And that's why OMED is here. It's like an assisting mechanism, a counterweight, if you like, when one of the parties reacts, they want to have individual employment contracts. We can achieve a collective arrangement. My question is addressed to anyone who wishes to answer it.
Κοιτάξτε, να κλείσουμε τον κατάλογο με την κυρία Βαρχαλαμά.
We will give the floor to Ms. Valhalama and to you, and that will be the end of this round of questions, because we need to speed up.
Μετά πρέπει να δώσουμε το λόγο στους ομιλητές.
And then we will give the floor to the speakers. Thank you, Mr. Chair. It's a great honor to have you with us here today. It's a great pleasure as well. My pleasure. Would also like to thank all the distinguished colleagues from abroad. My name is Eli Valhalama. I'm also a legal advisor to the General Confederate of Greek Workers and member of the Board of Directors of OMED. We welcome you all. Your presence here is very important, and I would like, with all the respect that I have for you, to address a question to Professor Servet, whose presence here today is very important. As was previously said, Greece has gone through many restrictive measures. Portugal knows that very well as well, because of the debt crisis and because of the mechanism that imposed restrictive measures. Portugal, to a certain extent, managed to go back to normality. We haven't managed to do the same. And to all these, another restrictive parameter was added, according to which the employees' organizations, the trade unions, that is, in order for them to have the right to collective bargaining, they need to be registered to the registry of union organizations that is controlled and supervised by the Ministry of Labor, the state, that is. If the unions are not registered in said registry, then all their fundamental union rights are suspended. All the rights provided for by the law. This is a case that is still pending in the Council of the State. There has already been a decision stating that this is contrary to the Constitution and contrary to international labor treaties and to the Charter of Fundamental Rights of the European Union. And I would like to ask you, we had seen on the basis of comparative study that in Ireland there is the so-called negotiation license. In Serbia, there is no registry. In Portugal, there is a registry. I would like you to tell us your experience about that and whether there are any sanctions, because freedom, when it comes to mediation and access to mediation, is a freedom of being, of existence. And in our country, this is a major issue. And dear Professor Servet, what is your experience from this type of restriction? Restriction of fundamental rights that are suspended, that are forbidden, to put it more bluntly, if the union organizations are not registered in state-supervised registries. Thank you very much once again for being present here today.
Λέγομαι Ντότσικα Μαρία.
My name is Dotika Maria. I'm a lawyer, and I have been mediator, arbitrator in the Organization of Mediation and Arbitration for many years. I would like to thank all of you for your presentations. And I have a very technical question to ask. What is the coverage percentage of the collective agreements in your countries, given that the system you just presented does not take into account the institution of compulsory arbitration, that is, the use of arbitration for reaching a collective labor agreement following a request by only one of the two parties? And the second question is the following. The basic rule of the freedom of collective negotiation states that there shouldn't be any state interference in the freedom of the parties. And my question is, how is it possible to combine, and I would kindly ask Professor Servet to comment on that, how is it possible to combine methods of compulsory arbitration as the one that was valid in Greece, with the general rule of the freedom of collective negotiations and the views of the International Labour Organization that encourage only the joint recourse to arbitration and exclude the unilateral recourse to arbitration, which they marginalize to a great extent. Thank you, Ms. Docica. I would like to give the floor to Mr. Servet last. Mr. Servet, would you mind?
No, so as to conclude the discussion. I will give also the floor to Belgium because it had at least two questions. Where is Belgium? Okay.
Question for you and for yourself. So, yeah, trade unions are required to register under legislation, but that legislation has been in place for 75 years. So every trade union in the country is registered. The legislation provides protection to the workers by virtue of being registered with the trade union. And I can't comment on the policy because the WRC doesn't develop the policy, we just implement the policy. We're the service delivery makers, it's government who develops the policy. But from a practical perspective, in terms of agreement in collective disputes before recourse to the labour court, in the absence of being a member of a trade union rules can't apply. So for example, if we're engaged in collective dispute and within a group of workers, a small group don't agree, you know, there has to be that mandate, that majority rules. So the WRC provides conciliation services to non-trade union workers, and that's what we call facilitation. So we provide that service, and the difference between the two is, first of all, they don't have the protections under the legislation in relation to strike action, and they also don't have recourse to go to the labour court. But in terms of delivering the service, it is there. But trade unions in Ireland have been there for as long as the legislation has been. You know, we don't have any newly established trade unions. So workers tend to join a trade union that exists. And most of our collective bargaining is done at enterprise level, not at sectoral level. So it's employer to employer to employer. I don't know if that answers your question, but that's the yeah. And I think it's similar to what you asked there in terms of the voluntary nature. How would I respond? You were wondering about the implementation.
I was wondering, without having any elements of, let's say, compulsory arbitration,
Yeah.
not by the agreement of both parties, how you might encourage the conclusion of collective agreements when this is only left to the discretion / freedom of the parties to agree or not to agree.
Yeah.
If you choose the freedom, you have no way for a resolution. If you see freedom as part of the peacemaking process for collective bargaining and concluding a collective agreement, then you might have to politically accept that even without the consent of both parties, by the initiative of one of the two parties, there can be recourse to arbitration and solution. It's a very difficult dilemma, and one has, unfortunately, to look at it and answer with yes or no, absolutely, either towards freedom, or one might have to socially dilute freedom into social responsibility and accept the non-agreement for the recourse to arbitration. Thank you.
So specifically in Ireland, that comes down to our constitution, which is every citizen in the country has a right to be a member of a trade union, but also to not be a member of a trade union. So the concept of enforcing a collective agreement on somebody who has a constitutional right to not be in a trade union. It's just not possible. Yeah.
Okay. Something about the coverage of trade union 22%.
Our coverage for sectoral collective agreements is very low, like less than 1%. But that's because our collective bargaining is on an enterprise level, so it's business to business.
And what's the coverage?
And what is the coverage of business to business?
We don't record it. They don't have to be registered. Yeah, they can be registered. The parties can choose to register them, but the voluntary nature of our system is that they just have them between themselves. No. No.
I will have to give you the floor. You were among the most questioned.
Well, first, maybe a small remark on this transnational issue. I think it's important that Belgium is currently a European presidency, holding a European presidency, and we try to make an evaluation of the European Labour Authority, and I think that's an important issue to discuss in this. What will be the future of the European Labour Authority? I think, and to make maybe space for mediation at the transnational level, and also the European Works Council directive will be revised. It was a late initiative of the European Commission. Okay, then maybe our coverage rate in Belgium is 95% in the private sector, because in the public sector we don't have collective bargaining. It's a statutory employment. So we only have protocols. Then, of course, why is it? I could say luck. It's institutional coincidence. We have made some choices in the past that have now this consequence. And I think if you compare, for example, with Germany, our neighboring country, where collective bargaining coverage is strongly diminished, it has to do, of course, that we make a combining of what we could call the French system and the Nordic system. So we have the same ideas about autonomy and responsibility, trade union density as, for example, Sweden. But we have it. But this situation is within a framework that is French, and French is typically state. The state regulates a lot. So we have. That's why, and of course, these regulations in Belgium on the state are linked to this Scandinavian type. So you have lots of things provided by the state, institutions provided by the state, but for a Nordic type of social dialogue. And then, of course, I can go into the state issues, like the professor already said, legal extension. That's not that's a global conclusion. I think that you will find ILO already have made in a lot of reports. Legal extension plays a big role. If you have, because why? If you legally extend the collective agreement, it means that somebody will decide on something, so you want to be involved. And that's, I think, the most important thing. Very often people think union membership is important. If you don't have a lot of union members, you will not have a developed collective bargaining system. My point is, that's not important. The important thing is employers' organizations. They make the difference. If you have employers' organizations who want to bargain, which is now less and less the case in Germany, if they have power about their rank and file and can convince these employers why you would bargain, and that is my next point. You always think bargaining is important for the workers. No, the issue that you have to make is that it's important for the employers. That's the issue. Why you bargain is a level playing field between employers. That's the issue that you have to have. If you that deliver as a collective bargaining system, then employers, what is the added value for the employers? That's the main question that you have to ask. What is the added value for employers? And for example, in Belgium, it's wage moderation. Wage moderation. Already for 10, 15 years, we have, and of course it's done also by a framework, by a legislation, but wage moderation, we have decided all together. Of course, not again. It's not always simple, not always easy. This is kind of discussions, but we have decided we will follow Germany in the wage cost. That's our prime rule that we use in collective bargaining. We follow the leader. I sometimes say as a kind of boutade, the unions in Belgium, they don't have to demonstrate in Brussels. They have to demonstrate in Berlin, because that makes a difference. Okay, but then So employers organization, legal extension, added value over employers. And then, of course, what we did, and that's, I think, separately from, and maybe something exceptional in Europe, that are these official joint committees. We say, in Belgium, if, of course, we don't do it by this. We do a very strong investigation. We look, are there unions, are there employers organizations that represent something? And then we say, you as a particular sector, you get a joint committee with a president from my department that will try to organize collective bargaining. That's really an institution. And why we developed it, I don't know. It existed in France in a very limited way in particular systems. We made our law very late, namely 1968. So we were very, compared to other countries, a very new law on collective bargaining. And so we developed these joint committees. It means it's an official organ. Most of them, they meet every month. And sometimes they discuss things, sometimes they have a very limited agenda. But because they are officially, we see also that it had as a result that, and that's the other point I want to make, don't start bargaining about wages. Start bargaining about other topics. If you look to the Belgian history, the first agreements were about health and safety in the mining sector, not about wages. So talk about other things, and that's what these joint committees do. These 2,500 agreements, we have 165 joint committees. So it means that on average, 10 to 15 agreements are made within the joint committee every 2 years. And one is on wages. But the other is on training, on end of the career measures, early retirement, I don't know, working time, flexibility, very important for the employer side, organized flexibility. And we see, of course, because they exist, they are really kind of reference point. It means also that in a lot of legislation now in Belgium, we refer to them. For example, the Belgian government introduced in 2022 an individual right on training. So every worker now in Belgium, by law, has the right to have 5 days training every year. But what was the part of the, because we have a government which is a very coalition government, a very weak government in Belgium, federal level, it's very difficult on the political side. So it's for them also easy. If they have big discussions, they make the law, but they say social partners can make exceptions, and that's done here. The individual right of training is 5 days, but the sectors, the joint committees can say, our agreement, we can go to 2 days or more days. So that's what we do in a lot of, for example, our early retirement system. It's normally now it's 63 years old that you can early retire. But in particular sectors, if you have a collective agreement, you can lower it to 60 years because of medical reasons, of heavy occupations. So that's we have all the time in a lot of legislation we say, and it's not related to wages, it's to other issues. Training, I mentioned the quality of work, flexibility, and these kind of things.
Thank you very much.
Thank you. Okay. Thank you. So you asked me about minimum services. If I understood you correctly, you were saying that Greek law has a minimum value for those minimum services to be set. Okay, in Portugal there is no minimum value. So it's up to the parties to negotiate which are the services that they consider essential and what's the minimum workers that they need in order to assure those minimum services. If they don't get to reach an agreement, then it will be set out by a joint order. And JERT will prepare that joint order. And how will we set it? We have 3 fundamental guidelines in order to set it, and they are expressly referred in Portuguese constitution, because the right to strike is a constitutional right, a fundamental right, but other rights, as the right to your health and to you going from somewhere to other, the right to transportation, are also expressed in the Constitution. So what the Constitution says is that we only can compress a fundamental right, the minimum necessary in order to assure that other fundamental rights are not excessively compressed to. So what are the three guidelines? Proportionality, necessary, and it must be adequate. So now you look at me and you say, but that says nothing. Okay, it's a case-to-case appreciation, but for example, I had a strike yesterday, a negotiation. It was the food service in elder homes, you know what I mean? Okay, they were going to strike, not only the food services, but also the hygiene services were going on are going on strike. And then the trade union reached an agreement with the employer. They talked about 30% of their services, but in some cases the joint order may go up to 50%. It has to be a case by case. I'll give you another example. The metro transport in Porto. When they strike, the workers strike, we end up not to set any minimum services. They never reach an agreement with the union, and they always say, oh, we need at least 50% of the workers, because otherwise the client's safety will be at risk, because there will be a big amount of people in the stations, and it could be a risk of security. And then we think about it, and we say there are other transportations in the city, bus, not as practical, but people can go from a place to another in collective transports, and 50%, it's a much high, it's too high in order to be, in that case, any minimum services. So it is, we don't have a standard. We need to analyze it case to case. When it comes up to the public sector and in private sector also, we tend to look at previous decisions. So decisions tend to be consolidated. We know that if it is a strike in a hospital, this service and that must be guaranteed, and the amount of workers are essentially the same. But I repeat, it has to be case by case, in a appreciation, casuistic appreciation. Did I answer a question?
Thank you, Mrs. Rio. Mr. Lazowicz, you want to add something?
So, answer for this question difficult for my language skills, but maybe support my friend. Okay. Maybe microphone.
I just want to add a few sentences about the minimum process of work. For example, in Serbia, we actually, our agency had obligation to start a process in the sector where is a minimum process of law, where exists a minimum process of law. We have some sectors. I think that 18 specific branches where the minimum process is required. So when we have, for example, strike in that sectors, we need to initiate the process of peaceful settlement of labor dispute. But maybe it's different in Greece and in other countries, so I don't see if we can compare it.
Thank you. For the record, your name, please.
Milos Prokic from Serbian Agency for Peaceful Settlement of Labor Disputes.
And now I think we can conclude with Mr. Seves.
Thank you. I will try not to abuse. I will go on first following our Belgian colleague. I think social dialogue is a very ambiguous expression. There's all kind of dialogue. If you take the last pension reform in France, the government indeed consulted the trade union, but that's just it. On the essential point, he was consulting, saying thank you very much, and following his line. That created problem. I remember I was very close at one time to the Italian Minister of Labor, Tiziano Treu, and he made also a pension reform in Italy with all the different systems. It was a mess. But it took 2 to 3 years, but it went on without any strike. But he did by consultation. And I think other countries could take advantage of this. When there was this very hurting reforms in Greece, I think more real discussion could have helped, even if you had very external pressure, which were indeed not very pleasant. To come back to the questions. First, goes every time to one ILO publication. It's not a very pleasant to read, but it's extremely useful. It's the compilation of the decision of the Committee of Freedom Association. You will find the answer to your questions over there. Compulsory arbitration, basically, no, except in public services and in essential services. The main question in the ILO discussion and debate was, what is an essential service? Teachers, yes or no, etc., etc. But the question is there. There's others, during the duration, the validity of a collective agreement. Basically that. So go to this compilation to see where it's accepted generally. The same applies to registration of trade unions. In a number of countries, you have a registration. When it's purely formal, to see if the trade union respects basic democratic rules within the association, in the election, in the publication of its reports, annual reports, in its finance, no problem. If you give some discretion to the administration, that is not permitted. You have in many European countries a system of predetermined criteria to select the most representative unions. Why not? If you predetermine and if just. You have it in Spain, you have it in Belgium, you have it in France, etc. Why not? But it should be purely formal and clearly established in advance. Not to give any discretion to the administration. Because administration means government and means politics. Okay.
We have something which is not written in the program, but as always, something which is not written in the program is at least as much important as those things that are written in the program. So Mr. Papadimitriou will explain further. It's for me, it's a very important moment, and I think for most of us.
Είναι μάλλον μια έκπληξη, δεν την περιμένει ούτε ο ίδιος, αλλά είναι έκπληξη. Και είναι για τον κύριο Κουγιάδη. τον καθηγητή. Πράγματι, η σημερινή εκδήλωση περιλαμβάνει και μια...
Indeed, this is a tribute to the Emeritus Professor Yannis Koukiadis, who not only contributed very much to labor law at the School of Law, but also to our organization. The contribution by Mr. Koukiadis to collective labor law was invaluable. He always was in favor of collective bargaining, the institution of collective bargaining. He was one of the first ones to write a manual on the topic. He used to be the president of the committee who drafted the 1950 Act on collective bargaining, which is still in force today. And it is about the terms of operation of our organization. But mainly, he was the first president of the organization. He was the second, typically, but he was the first who ran the organization, who put it in place, if you like. His contribution was pivotal. That's why the board of our organization unanimously decided to express publicly our thanks to him for his invaluable contribution to the foundation and operation of the OMED. He didn't know about it. This is the first time he hears about it.
Ήταν και ο πρώτος πρόεδρος της Οικονομικής και Κοινωνικής Επιτροπής.
Ήταν πραγματικά...
This is a highly emotional moment for me. That came as a surprise and I've got nothing to say. Well, anyway, since we've had this discussion today, let me make some points, nevertheless. The Act on collective bargaining goes back to the 90s. Throughout the 80s, the red bull, the red cloth was compulsory arbitration. When we started talking about that, we said no compulsory arbitration. Finito. But then I raised the question, what about SMEs, 90% in Greece? Most employees have a small trade union, cleaning ladies, drivers. How are they going to secure a minimum wage? How are they going to secure some minimum working terms? So the concept was not compulsory arbitration, but as a last resort, when there was no other solution, where nothing else could be done in order to ensure these small trade unions. The organization was put in place, and compulsory arbitration had the following effect. The number of collective agreements increased. There used to be 15 to 20%. It was increased, so a success. The number of arbitration awards was relatively small, but it was approximately 30%. 10 to 13%, okay. So the purpose was achieved as a borderline measure. And that's why the ILO was content. We secured a level of dignity for these people. But what's the funny thing? It worked like that. But you know, life is life. It holds surprises. At some point in time, compulsory arbitration began to be used by bigger trade unions, and this was cause for worry. And that's why it was abolished, compulsory arbitration was abolished. And the funny thing is that the trade unions that were against now are in favor. So the request for compulsory arbitration comes from the trade unions. Why was there this opposition?
Αυτονομία. Με τον ΟΜΕΔ η υποχρεωτική θυσία γίνεται από ανεξάρτητους μεσολαβητές διαιτητές που επιλέγονται από κοινού από τους εργοδότες και τους εργαζόμενους. Άρα το πνεύμα της ανοχής ή της συμμετοχής υπάρχει. Δεν υπάρχει το κράτος. Είναι οι εργοδότες και οι εργαζόμενοι που διοικούν τον ΟΜΕΔ και επιλέγουν τους μεσολαβητές.
Now the arbitration is provided by parties that have nothing to do with government. This is the difference. In the past, it was really government dictated, but now it's not. And that's why the ILO, in the end, accepted it, because there was common consent, and it also for its creation, and it also secured some minimum levels of dignity for these small-scale workers and employees. Well, nowadays, I know that the number of collective agreements was reduced. The big hope for me is after our partnership with OMED, conciliation became part of the OMED. If workers and employers choose to reinforce this institution, then a big part of the subject matter of mediation and arbitration will go away. Now there is some culture of consent. In the 80s, there was no culture of consent. They thought this was a communist notion, extreme, radical. It was something that the working class did not ask for, did not fight for. Now, the dialogue is the secret for the approach of employment and capital, because today it is accepted that employment must involve some dignity. Conciliation must be reinforced because it is to the benefit of both sides. These parties avoid mediation, and by avoiding mediation, they avoid arbitration, because mediation is a prerequisite for arbitration. If now they embrace conciliation, a big part of the problem will disappear. That's all I had to say. Thank you very much.
Παρακολουθήσει ελαφρύ γεύμα έξω. Τώρα,
There will be a light buffet outside the room. What time are you going to be back? No answer.
you said about 10 minutes intervention, not 20. 10, maximum 15, because you are late. 10, 15, huh? Yeah, you are set to come. Okay, then let's try 15. Okay, 15. Okay. Okay. With your permission, we'll start the afternoon session, which I have the pleasure and honor, thank you, Kostas, to moderate. The first conclusion is that we are a bit late, running out of time, so we are kind of 20, 30 minutes late, so we had a kind of short consultations here, and okay, we'll try to fit in the schedule. So, the first speaker this afternoon is coming from Spain, Eva Ruiz-Colome, so you have the floor.
Kalispera se Horus. Good afternoon to everyone. First of all, thank you for the organization, to Omed and Ailo. And I'm quite honored to be here with you. And after all, I'm going to explain how the solution, the mediation and arbitration service works in Spain. I followed what they gave us, so it might be quite long. I try to shorten it. First of all, for the legal nature of the organization, the Interconfederal Mediation and Arbitration Service is a tripartite institution. It's made up of the most representative trade unions and business organizations that are signatories of the Sixth Agreement on the Autonomous Resolution of Labor Conflicts, called ASAC, and of the General Administration of State. It has its own personality and capacity to act, and has, from a legal point of view, the characteristics of a state public sector foundation, supervised by the Ministry of Labor and Social Economy. About the financing of the organization, as a state public sector foundation, its resources are public in nature, so its actions are free of charge for the parties. Its annual income comes from two transfers, from the Ministry of Labor and Social Economy, one for expenses and other for investments. This allocation, with which the foundation is financed, is included in the state foundation sections of the general state budget and provides funds to CIMA, covering all of expenses. In relation to the foundation economic information, its accounts are published annually in the BOE, is the official state gazette. The nature of disputes, the disputes that may be submitted to ASAC procedures are collective, always collective, labor dispute between companies and workers or between their representative organizations. But always the territorial scope has to be beyond an autonomous community, which are those territorial entities in which Spain is divided, similar to federated entities. we always respect collective bargaining, and we encourage them, and we have full respect for parties' autonomy. About the entitlement to apply, they are the same parties entitled to file collective conflict claims before courts or to call a strike. The other relevant trade unions of the sectorial ámbito, the scope, thank you, has to be called by us in case they want to participate. CIMA may take initiatives aimed at stimulating bargaining activity and suggesting the development of its contest, although for the procedure to finally be carried out, the acceptance of such actions to promote collective bargaining must be jointly. So yes, CIMA can initiate, but there has always to be agreement in their acceptance. The other proceedings require a party's request. The state and the social partners' role is that in CIMA FSP, as a foundation, is governed by a board of trustees, and it's made of 17 members, 9 of whom are representative of general state administration, and the other 8 of the signatory organizations of the ASAC. So 4 are from representative of the employers' organizations, and the other 4 from trade union organizations. Its presidency is exercised on a rotating annual basis, but the administration always have vice presidency when does not assume the presidency. And in addition to being members of the Foundation Board of Trustees, the social partners participate in activities to promote and diffuse the CIMA's activity in order to inform workers and employers of its existence and operation. The director of CIMA FSP is currently a woman. Well, most of us are. We are. There is 9 of us there, and 7 are women. And she is elected. Well, she or he has to be elected at the proposal of one of the organization with presence on the board of trustees, but has to be accepted in a vote by the rest. And they have, with the full approval of all of them from that moment onwards. We have our offices just located in Madrid, which is very close to Puerta del Sol, very centric. And our timetable, although it reaches until 6 p.m. From Monday to Thursday, the opening hours for the registration of applications or any other document related to them are from 9 to 3 p.m., 9 a.m. to 3 p.m., from Monday to Friday, in order to respect the deadlines foreseen in the ASAC. About the procedure. We have mediation, promotion of negotiation, preventive mediation, and arbitration. Our figure of mediation is quite similar to conciliation. It's a mix. So it's not, you'll find the differences. In mediation, the mediator may propose solutions that the parties are free to accept or reject. But mostly they encourage parties to negotiate. The promotion of negotiation are initiatives aimed at the stimulating and suggesting the negotiating activity and the development of its contents. And the preventive mediation is the development of a normal mediation procedure, but without the existence of an actual conflict being. And the arbitration, the same of the other organisms have said, the arbiter adopts a binding decision. This might be the difference because in Spain his decision is binding and puts an end to the discrepancies. About the description of the procedure, to request the applications, they have the parties, one or two parties, one of the parties mainly, must submit a request to CIMA FSP Foundation, either filling in the standard form or by any other written document containing the information that allows us to have full knowledge of the parties involved and the characteristics of the conflict. In addition, it must be proven the solicitor organization has enough standing in the area of the conflict to enable promotion of the type of procedure chosen. Notwithstanding the above, certain types of procedures, such as arbitration or preventive mediation, require the request to be submitted jointly for both parties. Once the mediation or arbitration body has been appointed, CIMA FSP will call the parties to a meeting with them. The maximum time limit for that is, in ordinary collective disputes, 10 working days from the acceptance of the request. If everything is correct, we accept it. And in collective disputes, in the event of a strike, 72 hours, because it is an urgent procedure. Once the date and time has been communicated by CIMA FSP, it is possible to modify it if there is agreement between the parties. We take no minutes of everything discussed at the meeting, so the parties do not have to worry that what was discussed at the meeting is binding on them, except for what is expressly stated in the minutes of agreement or in the award itself. It is a highly flexible procedure which allows the parties to request the recesses they need, as well as holding of meetings between the mediator or arbitrator and each of the parties separately, all with the aim of facilitating the solution of the conflict. And if during the course of the procedural meeting it is deemed necessary to reconvene the meeting on another day to allow the parties to consider the proposals made, to prepare documentation or to propose some other alternative way, a minute of adjournment is drawn up for a certain date and time and for that specific purpose. In case of arbitrations, the arbitration body may ask as many questions as they need and request the necessary documentation to obtain a complete picture of the problem. The meetings of all procedures are mainly held in person, as for example you said, but access is facilitated through the Zoom platform for those cases in which it is impossible for someone to travel to our offices. However, the final result of the mediation will be recorded in a minute, which may be agreement, which it will contain the agreement reached by the parties in conflict, and well, in these cases, we give the parties, this is a lollipop, it paints in blue your tongue, so when parties go out, everybody knows that they have they reached an agreement, and they have to talk about us. This way. And the minute can also be of disagreement, where we just check the last of agreement, filling the file. This shall be done at the request of the applicant if he doesn't want to continue with the procedure, or in the event of his non-appearance at the mediation. And the other one is attempted without effect. That is the same, but when the party not requesting the procedure doesn't show. And in these cases, the effect is the same as a disagreement, so they could go to court afterwards if they want. In the case of arbitration, once the time limit has set by the parties in the arbitration agreement for the issuance of the award has elapsed, the arbitrator shall issue the arbitral award, which must be reasoned and communicated to the parties and to the CIMA FSP. The arbitral decision shall be binding on the parties and immediately enforceable. The agreements or the award must meet the legal standings requirements set out in Spanish law in order to be effective in general or in relation to third parties. Otherwise, the commitments or the stipulations made will only be effective between the workers and the companies directly represented by the trade unions, employers, organizations, or companies that have promoted the conflict or action and have signed the agreements concluding the mediation procedure or accepted to be bound by the corresponding arbitration commitment. Arbitration requires the express manifestation of the will of both parties to submit to the arbitration award, which shall be binding, as I said before. About the fees, as the CIMA FSP resources are public in nature, all its proceedings are free of charge for the parties, including the arbitration. About if there is second level, the reason, the quick answer is no. Because what has been agreement in mediation constitutes a title to initiate executive actions without the need for ratification in court. Furthermore, arbitration awards shall be deemed to be equivalent to final judgments for the purposes of definitive enforcement. However, if mediation has ended without agreement, the parties are free to go to court or, if applicable, to go on a strike. In the case of arbitration, there is no possibility of appeal in Spain, except for serious formal defects or for infringement of fundamental rights. About the judicial control of the award, the arbitration, it can be said that the arbitration award may be appealed in two ways: through the process of collective disputes in the same way as the challenge of collective agreements, or by means of proceedings for review of final judgment. The parties have to participate because they are obligated to attend the corresponding mediation instance as the consequence of the duty to negotiate implies in the nature of mediation. Thus, when the parties are duly summoned to the act of mediation and the applicant doesn't show up or does not give a fair cause, as I said before, the request for mediation shall be deemed not to have been filed, and the proceedings shall be archived, so they can't go to court or call the strike. If it is the other party who doesn't show, the mediation shall be considered to be attempted without effect, and the court later may impose the costs of the proceedings up to a limit of 600 euros, including the fees of the opposing party's lawyer who has intervened in the row. If the row essentially coincides with the claim contained in the request for mediation. Annually, about the following up of disputes that we rule. Annually, CIMA FSP monitors the cases dealt with in the mediation procedures of the previous year in order to know how the conflict has evolved in other areas. Thereby, the parties who participate as applicants and or directly affected in the procedure are questioned through personal interviews, although disputes that finally reach the National Court and obtain a judgment are sent directly to us by its secretariat, so that CIMA has immediate knowledge of the case. About mediators and arbitrators. The appointment. CIMA has an extensive list of mediators and arbitrators proposed and agreed upon by the signatory parties of the ASAC. And these are provided to the parties in conflict so that they are aware of its members and can designate whoever they deem appropriate. The mediation will preferably be carried out by a single person body, or if expressly chosen by the parties, by a collegiate body. We have a system to designate. If you are interested, I'll explain later. And for its part, the appointment of an arbitrator or the delegation of his choice on CIMA FSP must be agreed upon both parties, always. Their origin, they are the mediators and arbitrators included in our lists are professionals of recognized renowned prestige. The list includes labor inspectors, university professors, lawyers, trade unionists, former judges, and they have no relation with us. We call expressly for a case, for the concrete dispute. So once they intervene in the procedure, they invoice said activity to the organization, which retributes them, applying the settlement criteria approved by the Foundation's Board of Trustees. The activity of these professionals is guided by their consideration as good men. The people on the list must act impartially, demonstrate availability, dedication, and knowledge of the reality of the companies. They must also respect the principles and rules of the Interconfederal Mediation and Arbitration Service. And the guiding principles of the procedures are gratuity, speed, hearing of the parties, impartiality, equality, and contradiction. They have to respect as well the CIMA Code of Ethics and the legislation, of course, and constitutional principles. The text of the ASAC includes the figures of abstention and recusal, and well, if you want, I can explain that later. About the training of the mediators or arbitrators, we have a 100-hour course for the first time entrants. 40 of them are theory and 60 practice. And it's given by the organization itself and by external experts. In addition, training and retraining activities are carried out annually for those who already are in the lists. About the extroversions, the social partner, in relation to the social agents who are signatories of the ASAC, the CIMA management participates in the meetings held quarterly at the Board of Trustees. In addition, there is permanent and direct contact with them by telephone and email. With regard to the general public, numerous reports are drawn up on the data extracted from the procedures, and conferences are held to promote and disseminate the activity of the CIMA and the different procedures of this body. The subjects at whom all this activity is aimed are universities as future users of the system, trade union and business organizations as current users, and labor and judicial institutions as organizations with which it is necessary to agree on criteria for best possible functioning on autonomous conflict resolution. All possible dissemination is also carried out in institutional and professional media and through social networks. We are also in permanent contact with the other organizations that exist in Spain on the level of the autonomous communities. About the international activities, CIMA participates in every international activity in which it is invited, and in any case in those in which the ILO requests our participation. We also organize conferences on social dialogue and autonomous resolution of labor disputes with the participation of other organizations. And finally, it would be noted that the contact has been maintained not only between CIMA and the European Labour Dispute Settlement bodies, but also between the employers and trade unions organization on its board of trustees with their European counterparts. So I hope you find that CIMA plays a crucial role in Spain, and we think we do. And well, σας ευχαριστώ για το χρόνο σας. Thank you, everyone.
Thank you, Eva. Indeed, you managed to convince us that CIMA is an important player in Spain. I have found some interesting aspects which are actually some of the, let's say, guidelines the ILO sometimes recommend when we provide this kind of training. And especially what you mentioned about among the task, let's say, the missions of CIMA to initiate procedure to stimulate collective bargaining and to promote negotiations. Again, in light of discussion this morning, this is an important feature. And also the fact that CIMA received annual funding from the ministry, I understand, which of course is important for the operations of this kind of organization. Now, we'll jump from Spain to Sweden, and I'll give the floor to Irene Namo, who will present the Sweden model. Mm-hmm.
Thank you very much.
Swedish model, yeah.
Oh, okay. Thank you very much. Thank you very much for the invitation to this conference. It's really a pleasure to be here, and I have learned a lot. And I will have a little different focus in my presentation and focus a little more on wage formation and a little more on the mediation process, but I will come into that too. And in Sweden, as some of you know, we have very strong trade unions compared to other countries, but we have very few days of strike, days of strike.
So it's an interesting combination, and you have to go back rather long in the history to explain why it is like this. And it has not been that way always, I can promise you. So I start with this, and we have 1898, then the LO, which is the TUC, was formed. We had some trade unions even before, but then they were making a central organization. And also to that, we had the employers' organization formed in 1902. And the first negotiation they made, these two central organizations, was in 1906, and it's called the December Compromise. It was actually a copy of a Danish compromise in September 1899. We never want to admit that we always are imitating the Danes, because we don't talk about it in Sweden, but it's true. And as a part of this compromise, and you can say it in this compromise, the employers got the right to freely employ and dismiss employees, but also to organize the work. But the trade unions got the right to organize freely. And this is a really very important part of our model. It's in the constitution that the trade unions has this right. And as a part of this compromise, the first mediation office also was formed in 1906. So it's a really old institution in Sweden. But they weren't really successful, not so successful in the beginning, because we have an extremely high number of conflict days in the 1930s and 30s. We had the highest number of days lost in conflicts in the entire world. Norway also had rather high number, but Sweden was best or worst. So the government realized that they had to do something more to reach a better situation at the labor market. And in 1928, we had the first law on collective agreement. And in this law, it stipulated that if you have a collective agreement, then you don't have the right to strike. So it was the first legislation that limited the possibility for the trade unions to conflict. And we also formed a labor court. The trade unions didn't like this situation and the new law at all, but after 2 or 3 years they changed their mind and they realized that this was a really good court for them. So instead of striking, they went to court, and the court forced the employers to follow the collective agreement. And this law is in all important parts still valid in Sweden. So we haven't changed the regulations so much from 1928. Then in 1938, we had the Saltsjöbaden agreement. Saltsjöbaden is a really very exclusive suburb of Stockholm, and there the trade unions and the employers decided that have a big agreement, and the important part was that the trade unions and the employees really took the responsibility for organizing the labor market, both the taking care of the wage formation, the entire wage formation, but also labor laws and so on. And the political parties and the government could deal with other questions. And as a part of this, all big employers started to have collective agreements. But then we had some inflation crisis during, I have to check the colors. We have had some inflation crisis that has been very important for our model, because inflation is really a stress test for the wage formation system. We had one during World War II, and then we nearly had a revolution in Sweden. We had one during the Second World War, and then we nearly had a planned economy, because the market economy was really not in force during the Second World War. Then we had a very interesting inflation crisis in beginning of the 1950s. It was the Korea War that really increased the inflation rate in Sweden. And we had this model with collective agreements, and the employers and the government they were trying to find a way of dealing with this inflation crisis in a good way. And the result of this was coordinated negotiations that started in 1956. It took some time, but it was really a result of this crisis. And in this coordinated negotiation, there the trade union and the employers had negotiation on the central level, and then after that, they had stipulated the wage level that was okay in Sweden. Then we had sectoral level negotiation, and after that, local negotiation. But these local negotiations, there you never have the possibility to use the weapon of strikes, because you can use it just on the higher levels. This worked very well. In the 50s and the 60s, we have very few conflict. We had high real wage increases, and rather low inflation. But in the 1970s, we went in a new inflation crisis, as some of you possibly remember. We had a situation where the government was really inspired by the left wind during this period of time. They implemented some new labor laws that really was supportive for the trade unions and against the will of the employers. And earlier on, all these labor laws had been a result of negotiation, but here the political party intervened. And then we had these oil price shocks over the entire world, and it increased the inflation rate a lot in Sweden. And as a third factor of the problem that our model went through was the collapse of coordinated negotiation, because this had worked well, but during the 1970s, the white-collar workers had begun to organize into other central organizations, and they thought that they had had too small wage increases during this former period. And we also had a public sector, and they wasn't part of this model. So when the central part, the Trade Union Confederation and the employers had rather low wage increases, the white-collar workers could force through higher increases, and then, of course, everybody wanted them. And in addition to this problem, we also had problems. We hadn't any independent central bank. We had high inflation expectation. It was a lot of industrial disputes, especially on the local level, and most of them weren't not allowed a lot. And we also had a problem of wage drift, that the negotiation level was rather low, but then on the local level it was increased. So during the 1970s, Sweden went in a situation where it was rather high nominal wage increases, but inflation was also very high. So the real wage increase was very low during 20 years or so. So the political part, the government tried to find a way of coming back to a better functioning model than before. There was a lot of not successful attempts, but at least they was successful in 1997. And then we made a new model compared to the old one. And it's to some extent rather similar, but it's different. And today, it's not the central organizations that negotiate about the wage level, but it's the manufacturing industry that first have a negotiation round where they reach a conclusion. This is the wage level that is possible to have in Sweden. And after they have done it, other sectors have their negotiation. So they follow the industry. And then we, of course, have local negotiations. But of course, the manufacturing industry can't force other trade unions to follow them. And the trade union in the industry can't do it either. So we have to have some mechanism to deal with this situation. So both the central organization are taking responsibility to trying to force through the what we call mark in Sweden, the mark of the increase in wages. But we also have made a new organization or a changed organization in this Medlingsinstitutet where I'm a director general So we are always also following the industry. So if there are a mediation, we never let them get more than the industry. We can adapt the negotiation in different ways, but we can't let the cost be higher than in the industry. And so we have this new changed institution compared to the older one. They did some changes to make our possibility a little better. So they gave us a new objective, and it was to support a good working wage formation, because we had the situation in 20 years where the wage formation didn't work at all. And we should mediate in labor disputes, but we are also responsible for the national wage statistics, and we also do some economic analysis of the situation. And our authorities is that we demand a notice of industrial action 7 work days in advance. It's a little longer period than before. So they have to send in a copy of the notice to the employer, also to us. So we always know exactly what has happened on the labor market. We can call the part for consultations, and they have to come. And we also appoint mediators with some deviations. So we are taking the decision about exactly who won. It's often 2 persons that mediate in a conflict, and we are appointing them. We always try to find mediators that both the social partners accept and think this is a good solution, but sometimes we use our power because it's of some reason. We can also postpone a dispute for 2 weeks, and this is a new way. We don't use it very often, but sometimes we use it, and sometimes we tell the trade unions that we can use it, and then they often choose to postpone the dispute themselves. So it has an impact. And this is, of course, to get the trade mediators to have some more times to do the mediation. And the public sector isn't really a part of this model, but they have accepted it. So they are also following this model. And as you can see, it has really played a very important role. This is the industry agreement. The industry is the green, and then we have the black is the average, and then it's different branches. And we always compare with Germany in Sweden, because our industry structures is rather close to the Germans. And you can see that it plays an important role. No branches are really deviating a lot from the situation in the industry. So everybody follows it rather closely. We have very few industrial disputes. This is from 1970 until today. And the level of both days and number of conflicts has decreased a lot. And it's a very low level at the moment. We have also been rather successful in keeping the coverage of collective agreement on a high level. It's in the private sector, it's around 82%, but if you take together the public and the private sector, it's around 88% that have a collective agreement. And in big companies, nearly everybody has it. So it's especially the small companies where you can see a higher degree of companies without collective agreement. But it's really, and we have done some new studies on it, so we can see that it's especially among blue-collar workers, it's very common to have a collective agreement. Companies that just have white-collar workers employed, there it's a little lower. So this function is very, very good. We also have it's unfortunately in Swedish, I had some problems with this, and we can see the organization ratio is there. Earlier on, it was blue-collar workers that was best in organizing workers in trade unions, but today it's actually the white-collar workers, so we haven't seen any decrease when it comes to white-collar workers. It's on a very high level still, but the blue-collar workers has diminished a little. But I mean, compared to other countries, a lot of people are members in the trade union. And we don't have any minimum wages in Sweden, but but it's very unusual with low wages. This is the wage structure in Sweden. And you can see that it's only 1.2% of the workers, everybody that have working income, is below 60% of the national median wage. And most of them are actually are below 20 years of age and work in hotels and restaurants, which have the lowest wages in Sweden. So it's despite the fact that we don't have any regulation about minimum wages, it's like a minimum wage, you can see. It's very unusual with low wages. We have also reduced gender wage inequality during this period of time. During the pandemic, it stopped to decrease. This is both the income, working income, and wage per hour. And you can see that some people were, especially some female-dominated trade unions, was worried that when everybody followed the industry, that it shouldn't be good for the public sector. But we can see that the wage inequality has really decreased during this period of time. During the 1970s and 80s, there were big lack of trust between the social partners. But during the last 10 and 20 years, this trust has really come back to the system, which has been extremely important. And the social partners in the private sector, they reach a new central agreement. This is Swedish employers, and it's TUC, and it's the white-collar organization. They had a new central agreement about labor law, and to really find a common situation, common view on that, so they shouldn't go to the political parties to try to affect the labor law. But it was also a big package of possibilities to change go to studies again and so on. So it was a very interesting package that was presented. And so this is a totally new situation where the social partners really work together in another way than earlier. But then, of course, the last 2 or 3 years, we had a demanding situation like many other countries because inflation rate was increasing a lot. And we have wage round with between 2 and 3 years between this wage round, and we had one wage round in 2020, and then the level of wages in this mark that affected everybody was rather low because it was in the pandemic and the inflation was really very low, and then inflation increased a lot, and of course real wages decreased. But in the last spring we had a new wage round, and there were consensus about how much wages could increase, and it was around 4.1% last year and 3.3% this year, and it has been accepted. And during this wage round, where all the private sector was involved, we just had one rather short strike. So we lost, I think, 1,500 days was lost in strike last year, connected to this situation. So it turned out rather well, even if, of course, this type of high inflation is really a stress to the system. But I think that today is inflation decreasing again, and real wages is starting to increase. So I think we managed this situation very well, I would say. So I think I stop there.
Well, thank you, Irene, for this very comprehensive exposure to the Swedish model. I think everyone in the room has heard, to a certain extent, to the Swedish model as a success story. You confirmed that. I found it really amazing, this 1.2% below 60% of the national minimum wage. This is quite unique, I guess, in our region.
Yes, it is.
Perhaps how the Swedish model has kind of convinced the social partners to regain the lost trust could be a topic for another conference. How can someone bring trust back once lost?
It's a very good topic because it's very difficult when trust disappears, which really happened in Sweden in the 70s and 80s. And I mean, it was a lot of but it's very hard to get back again. But we have really been successful during this period of time. It started with a functioning wage formation, but then it really has been much more important for other sectors too. So it's a very good situation at the moment, I would say. Thank you.
So far we have heard from two systems with well-established institutions and practices. And now we are going to hear from Svetlana about a system which is defining these very days its architecture. And that's Ukraine.
Thank you all very well. I'm very happy to be here with you today. First of all, I want to thank the International Labour Organization personally, Christina Miches, and organizer of this event, Professor Kostas. And it's extremely nice to meet my colleagues here. Allow me share with you the Ukrainian experience of resolving labor disputes. I would like to take opportunity to present the report of the National Mediation and Conciliation Service for 2023. The printed version of the report looks like this. I sent this example for professors, and maybe it interested if you are you can familiarize if you are interested with this version, and you can use the QR code to quickly search for the report of our service in our official website. According to statistics, we have labor disputes in Ukraine are among the most numerous legal disputes. Moreover, in the conditions of martial law, the necessity of sometimes significant changes and the organization of business as a result of which there is a reduction or dismissal of employees, the suspension of the employment contract, and announcement and layoff, and another. Therefore, the problem of resolving labor disputes rising between the employer on the one hand and specific employee on labor team on the other hand is very relevant. The resolution of collective labor dispute is facilitated by National Mediation and Conciliation Service, which is permanent state body created by the decree of the President of Ukraine in 1998. In accordance with the law of Ukraine and the procedure for resolving of collective labor disputes, conflicts from 1992. The role of National Mediation and Conciliation Service, which is permanent state body created by, is implemented through the purpose of its activity, improving the state of labor relations, preventing the occurrence and facilitating the resolution of collective labor disputes. Our service carries out mediation and reconciliation in conflict situations, help to reach a compromise between employees, trade unions, and employers. And it also ensures the convergence of positions, the achievement of joint agreements, and the adoption of agreed decisions by the parties to the social dialogue. At the request of the parties to a collective labor dispute, our service proposes nomination of independent conciliator and members of labor arbitration, coordinate the work of labor arbitration, sends its specialists and experts to participate in work of conciliation bodies. Representatives of our authorities can participate in resolving a collective labor dispute at all stages. According to decree of the President at the formation of National Mediation and Conciliation Service, the maximum number of employers of our service is seat all 147 full-time. And to date, we have more than 200 labor arbitrators and more than 100 independent facilitators, conciliators, which registered in our service. Our service has a central office located in Kiev and region branches in 22 regions in Ukraine. The powers of the service's civil servants include not only assistance in resolving collective labor disputes, but also assistance and social dialogue. Our service constantly interacts with social partners following the law of Ukraine of social dialogue of Ukraine. National Mediation Conciliation Service evaluate compliance with the criteria of representativeness of trade unions and their associations, employers' organizations, and their associations too. Confirmation of representativeness is a necessary condition for the participant of trade union parties and employers of social dialogue. This slide presents statistics of collective labor dispute resolution in Ukraine for the period from 1999 to 2023. The service contributed to a settlement more than 2,000 collective labor disputes for this period, and if you can see, 97% was the result with the assistance of the service. As you can see, this slide presents the statistics and dynamics of dispute resolving by year. In general, this is from 100 or 200 disputes per year. During the period of martial law, we observe a decrease in labor dispute, which is connected with the war and its consequences. However, recent finding and statistics indicate a possible increase in labor dispute after the war, and we have to prepare for it. It should be noted that the powers of our service include assistance in the resolution of disputes at the pre-conflict stage. We have more than 100 disputes in 2023. You can see the sectors of economy in which such disputes arose, which allows you to understand that the largest number of disputes was in the field of healthcare and the smallest in the field of food production. The number of strikes, we have this information, a number of strikes and protest action over the past 10 years. As of now, during martial law, strikes are prohibited, but problems are accumulating. And after the war, their number will increase and be dynamic, we think. Our team is using this pause to improve our institutional capacity at the service and legislation related to dispute resolution. For the implementation of the national strategy in the field of human rights for 2021-2023, National Mediation Conciliation Service started the process of developing a new version of the law of collective labor disputes. There is no doubt to the main and firm working group of representatives of responsible executors. Representatives from partners of social dialogue, tripartite social economic council, public organization, experts. We have 56 meetings with our working group and we prepare draft law. Currently, the results of expertise of this project have been received from the International Labour Organization, which are being processed in the Committee of Social Policy and Veterans' Rights of the Verkhovna Rada, our parliament. And this Tuesday, there was such a meeting, and we considered the proposals of international labor organizations. Our service is the initiator of the development of the drafted law on Ukraine of social dialogue 2 in the new version. For this purpose, a separate working group was created to work out of model and content of drafted law 2. Labor disputes in Ukraine, we have three share for individual and collective. Subjects of individual labor disputes are the employee and employer body authorized by him. Subject of collective labor disputes are employees. Trade unions, they are associations or other bodies authorized by these employees on the one hand, and employers or employers associations on the other. Depending on the type of labor dispute, the procedure for resolving it is determined. First of all, we have general procedure according for individual labor dispute. We have general procedure considered consequently in the Commission of Labor Disputes in court. Judicial procedure on which a labor dispute is directly considered in court, and special procedure which provides to peculiarities of consideration of labor disputes of judges, prosecutors, civil servants, etc. In general, starting with the Commission of Labor Dispute, most arising for labor relations and considered regardless of whether employees in full-time, part-time, temporary, or member of trade union. The main regulatory legal acts in field of labor dispute resolution in Ukraine are the Code of Labor Laws, the Law of Ukraine and the Procedure of Resolving Collective Labor Disputes Conflict, and the Decree of the President of Ukraine on the establishment of the National Mediation and Conciliation Service. Of course, the legislation isn't exhausted by these acts. In 2023, the law on mediation was adopted and corresponding changes were made to the labor code. We have one article, settlement of labor disputes through mediation, which regulate this situation in our labor area. And important that collective labor disputes in Ukraine also have the prospect of resolution with the help of labor mediation too. According to Article 2 of the Law of Collective Labor Dispute in Ukraine is a disagreement that has arisen between parties to social and labor relations regarding establishment of new or changes of existing socio-economic conditions of work and industrial life, concluding or changing a collective agreement, implementation of a collective agreement or individual provision thereof, failure to comply with the requirements of labor legislation. Consideration of the collective labor dispute is carried out in issue provided by clause A and B in the Conciliation Commission, and points C and D, labor arbitration. It's necessary the Conciliation Commission involves an independent facilitators, intermediary, consults with parties to a collective labor dispute conflict, central and local executive bodies, local self-government, and other interested bodies. Labor arbitration is a body consisting of specialists, experts, and other persons involved by the parties and decides at the merits of labor disputes. The quantitative and personal composition of the labor arbitration is determined by the agreement of the parties. The chairman of labor arbitration is selected from among its members, people's deputies of Ukraine, representatives, and others. A collective labor dispute is considered by labor arbitration with the mandatory participation of representatives of the parties and, if necessary, representatives of other interested body and organization. The labor arbitration must decide within 10 days from the date of its creation. According to the decision of the majority of members of the labor arbitration, this term can be extended up 20 days, minimum or maximum time limit set by law. After making a decision to resolve a collective labor dispute, the Conciliation Commission shall cease its work. The decision of the labor arbitration is adopted by majority vote of its members, drawn up in minutes and signed by all its members. The decision of the labor arbitration on the resolution of a collective labor dispute is binding if the parties have previously agreed on it. But in Ukraine, there is no procedure for the enforcement of labor arbitration decisions. Organizational and logistical support for the work of the Conciliation Commission, labor arbitration is carried out by agreement of the parties, and if the parties have not reached an agreement in equal shares. In Ukraine, there is no appellate level collective labor dispute resolution. There is a conflict on this matter. This one of the objective reasons for the development of a new draft on the law of settlement of collective labor dispute. In our opinion, this approach contradicts the principle of legal certainty, which includes the obligation to implement the decision of courts in labor arbitration, and therefore the situation should be changed. So our team is working on it. The resolution of collective labor disputes by both a conciliation commission and labor arbitration involves the possibility of negotiations, conciliations, etc. The parties of collective labor disputes, the conciliation commission and labor arbitration, are obliged to use the possibilities not prohibited by law to settle the collective labor disputes. Conciliation commission and labor arbitration can work on remote online format. We have necessary information about our development. As already mentioned, the priority direction for the service were the development of the drafted law on collective labor disputes and work on the new edition version on social dialogue in Ukraine with the aim of adopting them and the standards of the European Union and complex conditions today. I think its important digital transformation has begun in the service. Personal potential has been strengthened, regulatory and legal acts have been streamlined, effective interaction with stakeholders and international cooperation have been established. International Labour Organization cooperates with social partners and make a lot of events. The chairman at our service, Dmytro Kukhnuk, visited the office of International Labour Organization in Geneva, and I think after this visit I have opportunity to be here and present information about Ukraine experience before you. To provide training and exchange of experience in November 2023 was a study visit what held by the management with our service in Turin in a seminar evaluated an institution for this settlement of labor disputes, and I need to thank Silda Landford who present a very interesting information. We use a lot of slides and a lot of information for our development. We searched and found, thank you very much. And I need to send my gratitude to my colleagues from Sweden. For example, Goranu Truginu, because we have common project, a new model and collective on labor dispute and collective labor dispute too, since Ren is here, and I need to send my colleagues this, my expectation. And I need to take, in the end, I want to thank the people who support my native country, Ukraine, in the Russian-Ukrainian war. This war is directed against humanity and democratic values, directly or indirectly harming not only Ukraine but the whole world. And for us, Ukrainian, it's important to understand that we are not only ones fighting this war. So thank you for listening to my report and support in this event. Thank you very much.
Thank you very much, Svetlana, for this very interesting, comprehensive, and passionate presentation of this under construction system. At the ILO, we have witnessed over the years the struggle to modernize a system to bridge the gap between law and practice. And I think we have excellent knowledge, and to congratulate you and the team you are part of for your determination to achieve this, this goal. So we are going to end this string of presentations with one of perhaps the most prestigious dispute resolution institutions in Europe, which is ACAS, again, I guess, well known by everyone in the room. Marina, you have the floor.
Can
Good afternoon, everyone, and thank you very much for staying the course, staying till the end. I'll try to make it quick so that you can all escape and get out of the very uncomfortable chairs. Quick word of warning. My name is Marina Glasgow. That tells you I do come from Scotland, so although I will be speaking English, it might sound slightly different, so just to bear in mind. Okay, so because I'm very conscious of time, I am going to shorten my presentation slightly, so I'm hoping I can fit it in with the slides, but bear with me if it seems a little bit out of touch. Just a quick history of ACAS. I thought we were going to be the oldest organisation in the room today. I think we might have just made it by about 2 years. So yes, I am the old lady of dispute resolution, and it feels like that most days. This is just to give you a flavour of how ACAS has evolved over the years. And we have evolved in line with the trade union movement in the UK. So they are a similar sort of age to ourselves. In 1975, we had our biggest change. We were separated from government and we became an independent organisation. So what does that mean in reality in the UK? That means we are not under any direct ministerial control. We are governed by the ACAS Council, an independent body appointed through the state process of public appointments, and they're there to set our governance, our direction, and basically make sure that we are balanced in everything that we do. We work with parties to resolve a wide range of disputes, both the ones that we've heard about earlier, the ones that are based in law, but also the ones that are based in interest as well. We've got a number of different factors as to how we do that. Obviously, we have evolved significantly over the years. And what I've put up on the slide just gives you that kind of brief oversight of our organisation. We are a UK-wide organisation, UK being Scotland, my favourite place obviously, Wales, very close to them too, and England, well, we won't talk about that in public, but that's just because I'm Scottish. We also have close relations with our neighbours in Northern Ireland, the Labour Relations Agency, and we work very closely with them, and we actually provide a lot of training for them, for their conciliators as well. This is just an idea of the range of services that we have in dispute resolution. We deal with individual cases, and there are over 100,000 of them a year. These are the ones where they are rights-based claims, where an individual feels that something's gone wrong in the workplace, and those are the ones that will normally proceed through to the Employment Tribunal, which is our labour court. We also have collective dispute resolution, and for my sins, I am the chief conciliator in ACAS. So all those big disputes that you hear about on the news, guess who's in there? Now you can say, oh, she's not doing very well, is she? But there's a reason behind that. We also offer what we call collective mediation. Now that's where collective dispute resolution isn't working, and there's more to the relationship between the parties. And we can separate that dispute out from the mainstream, and we appoint someone specifically to deal with that, but I'll give you a little bit more detail about that as we go on. We also have collective arbitration. And again, that's where disputes where we've been trying to help them find a solution that works for them have stalled or stagnated. And it's a way to find a resolution where an arbitrator will make a decision. But that decision is not legally binding, but I'll explain how that works as we go through. But we also offer individual mediation. Now, all of the other services I've talked about are funded by the UK taxpayer, but individual mediation isn't, because this is about a relationship between two individuals or an individual and an employer, and it's not appropriate for the taxpayer to sort that out. So just some key facts about our conciliation, our individual conciliation. Remember, it's a court system, so they have to submit a form within a time frame. It has to be correct, it has to name the correct legal entities, etc. And at that point, ACAS has a statutory duty to offer conciliation we must make contact with the parties. They don't have to talk to us. So we will offer the service, they can decline. If they decline, then we issue a certificate, their case can proceed to court. But in ACAS, we're a bit like little terriers. Once we get hold of you, we don't like to let go. And we will continue to offer conciliation right up to the date of the court hearing. This is in an effort to try to save court costs in the UK, and we are extremely effective in that process. About 78% of those 100,000 cases that come our way are resolved through one sort of conciliation or another, either in the early stages or after they have proceeded through most of the court system. Collective dispute resolution is the interests-based dispute resolution, and that's very different. There's no legal framework, there's no forms to be filled in, they don't have to come and talk to us, and we don't have a statutory duty to offer our support. What we do have is, under the Trade Union Labour and Relations Consolidation Act, that rolls off the tongue, we have a power to offer conciliation, but in effect we offer it every single time. It is voluntary, it is confidential, it is free of charge. Now, when I say it's confidential, it absolutely is. Nothing that's discussed in any of our conciliation processes can be discussed outside of ACAS. The parties have complete control over that. Even in an individual case, if the court asks us to come and, under a witness order, all we are allowed to say to them is, yes, I'm the conciliator who was appointed, yes, I dealt with the case, and the judge will normally say, thanks very much, Marina, off you go. And we won't disclose any of the discussions that have taken place. In our collective process, unlike our individual process, there is no time limit. If I tell you I have been dealing with a certain postal organisation in the UK, not naming any names, and we have been involved in talks with them under a number of different headings now for nearly 18 months. There's been strike action throughout that process, but unlike some of the colleagues who spoke earlier today, strike action can still take place while talks go on. That makes no difference to us. It's the willingness to get round the table and do the hard work. And for those who say that they finish at 3 o'clock, or my Spanish colleague, yeah, my latest finish, 1:30 in the morning, but that's another story. Our mediation, we also offer individual and collective mediation. Now, as I said, individual mediation, the key thing to remember is this is for a relationship dispute between two individuals or an individual and their employer. And you can see what's set out there. The agreement or outcome is not ACAS's, it belongs to the parties. It can be in writing or not. It is entirely up to them what goes into it. And if the mediation doesn't work, there is no sanction. What we do say to them is, if this hasn't worked for you, how are you going to work together from now on? And that usually helps to refocus some of the discussion. Our collective mediation is a different service, and that's where a collective dispute has become really intransigent or locked in for some reason. We offer that, and we appoint an ACAS-appointed arbitrator. Now, these are professional people. We've got ex-HR professionals, lawyers, ex-judges, academics, people who we feel, I think was it you talked about people with some real standing in the field of employment relations. Those are the kind of people who apply to be our arbitrators. And again, they're appointed by ACAS. Basically, I get to scrutinise everything about them and decide whether they get the tick in the box or not. It is not a time-bound appointment, because they're self-employed individuals and they can refuse work from us, but they don't work for ACAS. Basically, they are then allowed to make decisions and recommendations in that mediation that an ACAS person wouldn't, because we are and have to be impartial. Collective mediation can often help unlock a dispute, and sometimes that can be the end of it. Sometimes it can mean the parties come back to the dispute in a better shape to be able to find a resolution, and we do find it highly effective. Collective arbitration is the last tool in our toolbox. And again, this is for those really protracted, difficult disputes where we get both sides to agree to go to arbitration. Now, that's the key thing. It is voluntary. All of our services are voluntary. We appoint the arbitrator, again, through that panel. Our arbitrators and mediators wear two hats. The individuals have no choice in who we appoint. They put their trust in ACAS to find the right person for the job. They don't pay for arbitration because it is a dispute resolution function, so it is state funded. And since COVID, it is now done completely online. There are no face-to-face meetings anymore. It's a bit like a mini courtroom, so submissions are made prior to the hearing. The hearing is digital, and the arbitrator will make a decision. The decision is not legally binding, but the agreement that the parties sign up to before they go to arbitration is what binds them. That's where they say, whatever the outcome is, whether I like it or not, I will accept this and I will live with it. However, what I can say, like a number of people who have spoken today, the take-up of arbitration is diminishing significantly, and I think that's because people have become more litigious as a culture and want to be able to go to court and then have a right of appeal if they're not happy with the process. So that's a very, very, very rapid romp through. But what I will say to you is that's not everything that ACAS does. We invest a lot in our stakeholder relationships with politicians, with trade organisations, with the different trade TUCs, with employers' organisations. Our ACAS Council has a broad sweep of these people sitting on the council. We talk to them, but more importantly, we gather intelligence. We don't want to go out and start telling people what to do. We want to listen to what their problems are and help influence the debate and the discussion as to how to do this better across the whole of the UK. We are very, very visible, and I think it was somebody made a comment earlier on about how visible we are in the UK. Only 24% of people in the UK work in an organisation that formally recognises a trade union. In the 1970s, that was 74%, so there's been a massive decline. So one of ACAS's concerns over that period of time is, how do we reach those workers and those businesses that don't know about us? Because most trade unions do, and they take it as read that we'll be there for them. So we've done a lot of work over the last decade or so to reach out to organisations where there's no formal representation in place, to make them aware of our services, and to try to help them get it right. As I often say to people, we help them to fall out better. In other words, they can have their argument, they can have their disagreement, they can do their deal, and then they can continue to work effectively together. We do a lot on social research, and we produce guidance and publications, including non-statutory codes of practice. We are the go-to people for the government to come to when they need something like that, and they have asked for our advice recently on things like minimum service levels, which has come into the UK, and we're also now talking to them about potential changes towards sectoral bargaining in the future. Watch this space. That might depend on what government we get later on in the year after a general election. We are predominantly known for our dispute resolution. 60% of our workforce of 1,000 people are focused on dispute resolution. There's a lot of it about, but we have very, very high success rates. My team have dealt with over 700 collective disputes in the last year. 92% of them were resolved successfully. Of the 90,000 individual disputes, 78% have been resolved without people having to go to court. I think that's a statistic I can be rightly proud of, and I can give all credit to my colleagues for the hard work they do day in, day out. But we don't just try to fix the problems, we try to prevent the problems. So over the years, over the last decade or so, we've built up quite an extensive training and advisory service. We have a helpline. You can phone up and ask them what is the current rate of national minimum wage, or you can say, I'm an overseas worker, I feel like I'm being discriminated against, I don't know who to turn to. Whatever your question is, our helpline are there to give you the answer, and they're there 5 days a week, and they can put you through to someone for a more detailed conversation. Our trainers try to educate people on best practice. Sometimes that's a lesson people don't want to hear because it doesn't quite fit with what they'd like to do. I think the most common question I get asked is, how do I sack someone and get away with it? When I'm able to fill Wembley Stadium and charge you all a lot of money, I'll give you the answer to that. But the biggest thing for us is partnership working. Being actually out there with other bodies, with the ILO, with anyone else who wants to talk to us, to get the message out there about we are there to support equally, impartially, both employers and employees, because that's what contributes to the bottom line, and that's what makes the UK work. I'm going to stop talking now because I think I've managed to get this in relatively quickly, so thank you for your time.
Thank you very much, Marina, for the very rich presentation. I think that ACAS has raised the level of innovation in terms of alternative of out-of-court resolution of disputes at a level which is hard to achieve. And thanks also for raising the very important issue of visibility and proactive outreach action. ACAS, again, is performing very well in this field. Now, I think we still have some time for questions. Okay, burning questions. Who would like to launch the first burning question? Yeah. Okay. Yeah. So, yes. And then, yeah.
Maybe for the three speakers from Spain, from UK and Sweden. For Sweden, could you briefly explain what is the strike rights from somebody at the individual level, at local level? Because you give the impression that if you are not linked to a sectoral dispute, you can't strike in Sweden. But maybe it's just wrongly heard. For Spain, for me, you explained you do a lot of training of these conciliators and mediators. For me, it's important to know. Of course, you have the legal and the institutional things you probably explain. But for me, it's important what kind of generic skills you try to train these people. That's maybe also a question for the people from ACAS. I think. Yeah, how you, what are the particular things, and more about what we call generic skills and not technical skills that you more social competence and these kind of things. What you try to learn them.
Yeah, we have. I mean, it's generally we have a possibility to strike, but there are one exception, and there are a collective agreement that is binding for this employer and the trade union, you can strike. And most of the collective agreements are 1, 2, or 3 years long, and during that period of time, you can't strike. But then it expires, and then you have this strike possibility again until you sign a new collective agreement. But then if the company don't have a collective agreement, then everybody can use whatever they want against them. And of course, that's one reason why we have so high degree of collective agreement, because everybody can use their power against companies without collective agreements. But a lot of collective agreements, then they, for example, in the industry, they have wages should be increased with 4.1%. But then on the local level, they can negotiate about how do we do in this industry, which groups should have 5, which groups should have a little less, and so on. But there are no possibilities to use in labor disputes to increase the wage even more. And that types of, and if they use industrial disputes in this situation, it's then the employer can go to the labor court and they are freed. So, thank you.
Well, as the skills we ask for in that course for mediators is, for example, negotiation skills, is to learn a minimum, at least, of how the procedures go. We teach them some communication, just skills on communication, verbal and non-verbal as well. We insist a lot in the principles we want them to follow, the impartiality, to give the same chances to both parties, things like that. We made this a few years ago, well, a couple of years ago, I think, but it's only in Spanish. It's a pity. We have to translate it because it's made up on the work of all our board of mediators. We made a meeting with all of them, and they began to do a brainstorming of what shall and shall not be done by a mediator, and this came out, and it's quite a nice job. So if we have the chance, we'll translate it and set it into our web. If you want, I can give it to you. Thank you.
So what particular skills or what generic skills do you need to be a conciliator in ACAS? Patience, empathy, determination. We have conciliators who come from a wide range of backgrounds. We have people from a legal background, we've people from HR backgrounds, we've got people who have managed catering firms. What we look for is the person with the right mindset, and we put the training in. Our training includes things like extensive training in employment law, UK employment law, negotiating and influencing skills, because if you can't influence, you're not going to be effective as a conciliator. And we, more and more over the last few years, we've looked at behavioural insights, psychology training, understand the psychology of disputes, you know, understanding group dynamics, how to influence that, etc. It is currently evolving. I took over this role just about 2 years ago, and being a woman, I've looked at it and said, needs a bit of a shake-up. My husband says I'll do the same thing at home all the time. And we're actually now in the process of starting to develop our own professional qualification, because what we found in the UK was there wasn't anyone out there who could meet our demand. We've realised we are actually the experts in it, so we're going to do, in accreditation with probably the University of Warwick, we're going to develop our own training and qualification.
Maybe I need to add some words about Ukrainian experience in regards on collective negotiations, first of all, because now, as you know, strikes are prohibited in Ukraine in this period of war. So in Ukraine, we have such situation, a lot of collective agreements on the local level and national level. And we have a big problem with sectoral, industrial level. We discussed about it before this section with Irena. And it's really important Swedish experience and experience all of the country, because we have a big hopes beliefs for development at the level of this industrial level, which create for all general national standards and labor relationships, and which we can relate with, implement standards of international in our area. And I hope negotiations prepare mediators in this area, teaching them can help us to not only develop a situation, change level standards and change legislative and total situation in Ukraine. Thank you.
Hello, I just have a quick question for Sweden and Greece as well, if you don't mind. Irina, you mentioned about pay agreements that you've reached for this year and next year, the 4.1 and is it 3.3? So is that every worker in the country is getting that percentage increase? And if the answer to that is yes, then my follow-up question is, how do employers attract talent if everybody is getting the same pay increase? Are there other incentives, or how does the labour market operate? And then my question for Greece is, you mentioned unilateral recourse for arbitration. And my question was, who is taking that unilateral course of action? Okay.
Strike at this level, so there are deviations, and we don't regulate, mostly we don't regulate the wage for newly employed, so you can employ on which level you want, even if it's it's complicated to give one too much, then everybody will be upset. But there are this possibility, and in some sectors are the wages is very regulated. In some sectors we have minimum wages in practice that most are rather close to them, but in other sectors there are much more freedom for the employers to use, and there we could see that the wage increase was a little higher during the last year and it was in some sector, for example, the IT sector, where it was a lack of personnel so we have some flexibility, I would say, but it's important for the model that most people follow it rather closely, because if some groups get much more, then of course everybody wants to have much more.
Concerning Greece, if I understand well, unilateral arbitration, there are in three cases. First, concerning essential services. Second, concerning interests of general interests of Greece, very important. And finally, there is another case concerning minimum service. There also there is a possibility of unilateral arbitration. Each party is entitled to request, even employees or employers. That depends. Everyone, both sides.
Not the arbitrator.
No.
If there's a dispute, the state doesn't come in.
Not the state, not Ahmed, not me, only one of the parties.
Okay, thank you.
Thank you.
I am Sofiana Vergou, a jurist, a member of the board of OMED.
Well, regarding to digital platforms, I want to ask the following. Leaving the traumatic experience of COVID era behind us, or in some cases still still living a war experiencing a war. And taking as granted that the need of providing services of conciliators and arbitrators to everyone. What is the balance between access for everyone and the quality of services? I mean, through digital platforms, either because of COVID, or because of war, or because of having people living or working far from the center where the organisms is established. We provide the services through digital platforms. What is the quality? What is the balance between giving everyone the access and the quality of services? I'm sorry, it was too complicated.
Well, I can tell you about the UK experience. We had COVID lockdown announced on the 23rd of March. It's burned into my brain because on the 24th of March, my boss phoned me and said, "How are you now going to run a service when you can't meet people in person?" And I didn't have the answer at that time, but about 2 hours later I did, because I found something called Zoom, and then I found all the other platforms as well. What we have done is we have looked at where it is most effective. So some of our individual meetings or setting up meetings, when you talk to people about, what are the fundamentals here, etc., we do them digitally because they are quicker, cheaper, and they have saved me about 15% in human resource in terms of, access to the service. What we do give our people is autonomy to decide when it really needs to be in person, because that's an expensive service for anyone to run. You've got overheads, you've got travel time, you've got the time of the parties away from their business, etc. But we know that there are times when disputes are incredibly difficult. The only way to resolve them is to have the parties in the room together. That was my 1:30 in the morning finish one. That was one I wish had been digital. So we are judicious in how we use it. But in mediation, it's about 50-50. In arbitration, it's 100% because that's a very formal process. It's almost like a courtroom. So actually we found it was the best use of time and resource, and it reduced our costs by 60% in running arbitration, which is not a figure you can ignore. In terms of collective dispute, it's about 35-40% digitally, the rest is in person. But we're doing a big evaluation of it at the moment, and by June this year, we should have the results from our customer survey, that's both employers, trade unions, etc., telling us how it's been for them. And obviously we will adjust and develop the service depending on what that says to us.
About Spain, for example, during COVID, we discovered this thing called Zoom, and we used it, I guess, as anyone, and it worked quite well because we were all in the distance, and we all wanted it to function, to keep normality, if you remember. But as soon as COVID, the normality came again, we used this mix, which I think is not the perfect system. In fact, we encourage the parties to come in person to our offices, as I said before. For example, one of the ways of we insist in the formation is the non-verbal communication. Is so important in collective bargaining, and it gets missed when you have someone online. And besides, the people in presence, they are feeling everything that is going on the table. But the people online, they can switch off the screen, even though we don't let them. but they can be doing other things, other works, and maybe when they reconnect, they find it quite easy. They haven't been in the negotiation, so it's quite disturbing. So we encourage very much parties to come to our offices.
Dispute resolution. So for both collective and for mediation, yes, we used it during COVID, but our data showed that the resolution of disputes decreased. It involved more sessions and more engagement, bad behaviour on the part of parties, you know, in terms of honouring the process. So we actually have a policy now that all of our services are delivered in person, except for exceptional circumstances. So they would be around reasonable accommodation for disability, for example, if somebody can't travel, or if a key decision maker is based outside of the jurisdiction, so they'd have to get a plane. But apart from that, we deliver all of our services in person. I think maybe one slight difference to other countries is we go to the dispute. So it's only people who live in the capital come to us, but for everywhere in the country, the conciliator goes to the parties, so that we're not, and we ask the employer to provide the rooms. So that we're not taking people out of the workplace, because you'll have workers who should be working and managers who should be managing, so we go to minimise their time. But in terms of outcomes, success, we have found that online does not work. Yeah.
That's okay, says the boss. Now, shall I continue with the plan? Okay. So now I'm going to share with you that Professor Papadimitriou has kindly asked me, as I still have the mic, to draw some conclusions. I'm not going to pretend that I'm making the final conclusions, but humbly I am going to share with you some takeaways. And of course, perhaps you could compliment them. So I think we have had a very interesting and very rich discussion, and a very good day in terms of exchange of practices, good practices, and knowledge. And my first takeaway is that the topic we are discussing is strongly contextualized, but with a common goal, and that is to get a resolution of labor disputes. So ultimately, to improve access to justice of both workers and employers. So perhaps we could distinguish between a set of differences and also a consistent set of commonalities. And differences obviously are stemming from, as I said, historical, economical, cultural context, traditions, customs, culture of social dialogue, culture of collective bargaining. Obviously, the appetite for collective bargaining makes a difference. And as we know, again, very well at the ILO, and it's kind of common wisdom, when collective bargaining is well developed culturally, traditionally, then the parties are prone, have this, or tend to resolve their disputes through these alternative methods, out of court, through dialogue, through negotiations. When collective bargaining is underdeveloped for various reasons, again, historical, economical, tradition, cultural, then the parties rush to court to get someone to tell them what is the solution to their problem. Then we have heard about a diversity of institutional settings. Legal sources for these institutions and also their scope. Some dealing with collective disputes only, some dealing with both collective and individual disputes as well. And a variety of combination, of mix of procedures. But at the end of the day, they are very similar in their essence. And the essence is the third neutral, independent, impartial party to get in, to assist, to help the parties get a resolution of their disputes. Then I will end this, let's say, non-exhaustive list of differences with what I would call non-homogeneous terminology. So again, we have heard today about different meanings of conciliation or conciliator, mediation or mediator. For some, conciliation or conciliator is the peacemaker, is more passive, let's say, approach. For others, mediators is a more proactive. The mediator makes recommendation, must make recommendation in some cases, and so on and so forth. For the ILO, for instance, mediation is interchangeably with conciliation because of the essence of the process at the end of the day. Yeah, that's, again, a very vast domain where we could discuss. And now, to end on a positive note, commonalities. And I will start with basic principles, which are the same. And I have heard today independent, efficient, impartial, neutral, free of charge, voluntary, and we could continue the list, transparent, accountable, fair, fast, and so on and so forth. And perhaps this is an area where the ILO, and actually there is an initiative in this respect, could could gather all this thinking around some perhaps common foundation of what is mediation, conciliation in labor disputes. And since I still have the mic, I would like to thank Kostas, first of all, for this very nice initiative. Thank you very much for having us, having the ILO, having me and the presenters, and great opportunity to see you again and to meet with the other colleagues. Thank you very much. And now I give you the floor for the proper conclusion.